Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth. Draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Okay, good morning and welcome to today's sitting of the Appeals Court. Let me begin by introducing the panel to you. I'm joined today by Justice Jeffrey Kinder and Justice Suk-Young Shin. And my name is Ariane Vuono. And I want to thank you on behalf of the panel for participating in today's argument remotely. Just a reminder before we begin, the same rules of appellate procedure apply. You each have 15 minutes for your argument and there is no rebuttal. I know that you both argued before us before, so you know that we've read everything that you've provided to us and we know the records, so you can get right to your arguments. The first case is Commonwealth versus Cheyenne, Toledo, 2020-0234. We'll begin with Attorney Griffin.
Good morning, Your Honors. Can you hear me okay?
Yes, we can. Can you hear us? Or can you hear me at this point?
Yes, yes.
Great.
May it please the court. My name is Geraldine Griffin. I represent Cheyenne, Toledo on appeal. Your Honors, there are two issues on appeal in this case. One has to do with the sufficiency of the evidence of identification, and the second has to do with the admission of some hearsay statements made by the victim to responding EMTs and police officers. With respect to the sufficiency of the evidence argument, in this case, Your Honors, there were no witnesses to the assault on the victim, which appears to have happened in her apartment, and the victim didn't testify at trial. The only identifying information with regard to who the perpetrator was provided by the victim to a neighbor and to the responding EMTs and officers, and she identified the perpetrator as her boyfriend. She did not give any name or any identifying a description of any kind to those witnesses. The defendant in this case, there is no dispute, is the victim's husband. Despite this, the Commonwealth's theory of the case was that when the victim said my boyfriend, what she really meant was my husband. Problem, of course, first of all, with this theory was that a husband and a boyfriend are two different things. So starting right off the bat.
Question, if I might just ask you a question, wasn't that issue for the jury to resolve? If she, in other words, whether or not she was referring to her husband rather than another person, a boyfriend, wasn't that issue for the jury to resolve?
Well, only if the evidence was sufficient for the jury to be able to draw a reasonable inference that that is what she meant. The judge, when a motion for required finding is filed, the judge is supposed to act as the gatekeeper, of course, to prevent cases with unreasonable inferences or inferences for which there is no basis from even going to the jury in the first place, which is essentially what the defense attorney argued in this case when the motion for required finding was filed.
But speaking of inferences, if, as I recall, when the police appear, the victim's husband is present outside, intoxicated, in a t-shirt in March with a bruise on his face, and then attempts to leave the scene, why wouldn't it be reasonable for the jury to infer from that evidence that the person outside, the husband, was the same person that the victim referred to as her boyfriend?
Well, for a number of reasons, Your Honor. Just getting past the fact that obviously if she meant husband, you'd think she would have said husband. But beyond that, the things that you're pointing to, for example, his presence outside the building, what appears to be several hours after the assault. First of all, presence alone, as we know, is not sufficient to support a conviction. And in this case, like I said, the assault happened from the Commonwealth's witnesses. The only evidence was that the assault happened sometime before 4:30 in the morning, when the police arrive at 7 o'clock in the morning. So you already have a significant time gap between the time of the assault and the time that he's present, at least near the scene. I mean, he's not in the apartment. There's no evidence he was ever in the apartment or lived there, but he is outside.
Can I ask you a question? Can I ask you a question about the timing that I found a little confusing? So the police testified that they were dispatched shortly before 7 o'clock. And apparently the judge did review a transcript or a recording of the 9/11 call made by Mr. Baroa, I think is how you pronounce his name. But what was the time of that 9/11 call that was made?
There's nothing in the record to indicate what time that call was made. You're
All right,
right.
so I didn't miss anything there.
I'm
Okay.
sorry?
So I didn't miss that. I was trying to determine whether, so
No,
can
the
we
only,
infer?
the only evidence that was admitted before the jury was the 3 witnesses that were the neighbors, and they all testified that this occurred sometime. They started hearing noise around 3 a.m. and another person was woken at 4 a.m. and then she knocks on the door at 4:30. So clearly it's happened probably, you know, shortly before 4:30, but it had to have been before 4:30 because the only evidence, excuse me, the only evidence the Commonwealth introduces about time is that she knocks on the door of the neighbor's apartment at 4:30 and she's clearly already been assaulted. So
let me just interrupt you for, excuse me, let me interrupt you for a second. Although the officers were dispatched shortly before 7 o'clock in the morning. And is it a fair inference that they received the 911 call close to the time that they were dispatched, like probably within?
Oh, of course. Yes,
right,
yes.
okay.
I'm sure there's no,
So
in fact, yes, go ahead.
We can infer then, you would agree that it was a reasonable inference that the 911 call was placed close to 7 o'clock in the morning.
I do think that's a fair inference. I would point out, and you know, this is kind of important, the Commonwealth in the brief filed on appeal, I think it's in note 18, sort of asserts that there's conflicting testimony or there's conflicting evidence about what time the assault happened. But there really wasn't. They had, you know, there's out of 5, I think, total Commonwealth witnesses, 3 of them testified to what time the assault happened. So to come back now and say that he's outside the building, you know, present outside the building minutes after the assault, it doesn't jive with the evidence.
I think the point is that the jury could have disregarded some of that testimony. None of those 3 witnesses testified. Some of them anyway appeared to be testifying somewhat reluctantly, one in particular, who didn't have much memory of what happened that evening. So wouldn't that have been a factor for the jury to consider in terms of determining what time the Miss Aponte actually came to the door?
No, I don't think so, Your Honor, because they would have to have some other evidence to hang that on. And they don't, it's not like the officers testified that she said she had just been assaulted. The officers have no way of knowing what time she was assaulted. All they can testify to is when they arrived. So they could disregard, my point is they could disregard those other, as you're saying, reluctant witnesses, but they would have to be able to point to something else, or else they're just using conjecture.
Is this the fact? Is this part of your argument that the judge erred in determining that the victim in this case was still under the influence of the event, and therefore, as the judge ruled, that the statements were spontaneous utterances? Excuse me.
Yeah, I mean, I think it goes to that as well, Your Honor. Yes.
So is it a reasonable reading of Baroa's testimony that he was woken up by the victim screaming, and he pretty immediately called 911 and then went back to his room? So if it's a reasonable inference that the officers arrived within minutes of the call, and it's a reasonable inference that Baroa called 911 pretty immediately after he heard the screaming, then isn't the Commonwealth correct that the jury could have found that the officers arrived pretty quickly after the actual incident?
No, Your Honor, I don't think there's any way to reach that conclusion without, number one, not disregarding Mr. Baroa's testimony, but reading into it. You would have to really read into it something that's not there. He testified, if I recall, that he's woken up, or he comes into the kitchen or something, he sees the victim, and then he says, after I called 911, I went back to my room because I had to be at work at 7. There's nothing to indicate whether there was a waiting period between when he arrives in the kitchen, and who knows? I mean, I would have to speculate. Are they talking to the victim? Is she resting? I mean, the point is, we just don't know what happened between 4:30 and 7. So my point is, with a motion required finding, in order to get to this assault happened at 6:30. You would have to completely be guessing and reading into stuff into the evidence that's just not there. So in addition to the presence issue, Your Honors, if there aren't any more, if we're done with that part of the questioning, I would just point out, there's lots of cases that even if you could say he was present, okay, again, he's not in the apartment, he's outside, it's hours later. There are lots of cases that talk about presence alone is not sufficient to support a conviction. Even presence combined with lots of other things. If you look at some of the cases that I cited in my brief, like Maza, like Gonzalez, Prentice P, you have situations there where you had a defendant who was present at the scene, and there's all kinds of other things. There's motive, there's consciousness of guilt. Even with all of that evidence, there has to be more to identify that this person was the person that either the victim was referring to or described or named, and there's simply nothing there. And it's quite distinguishable from the case, for example, that the trial judge relied on when she denied the motion for required findings. She specifically referenced I think it's Rady, I'm not sure I'm pronouncing that right, but it's cited in my brief. The Rady case, if you look at that case, Your Honors, there is much, much more circumstantial evidence in that case to support that the defendant was the perpetrator, including the victim actually naming the defendant to one of the officers on the scene. So it's really, really distinguishable. And also the Commonwealth's cases that are cited in their brief as Cordell, for example, again, much, much more evidence, circumstantial evidence supporting the identification, and the Blackmer case as well, where there was a description given of the perpetrator at the time of the actual crime that matched the defendant. Again, here we have no description. I know that the Commonwealth points to a couple of other things, like the fact that the defendant was wearing a t-shirt and it was March 17th, but the Commonwealth didn't admit any evidence as to what the weather was like. So, they can say that and you can guess that it was cold, but the Commonwealth has to prove their case. And they can't just come out now and say, oh, it was cold, on March 17th. We don't even know how long he'd been outside. Maybe he had just parked his car and was walking. There's just nothing, there's no contextualizing of the evidence to support some of these circumstantial things that they point to. And then with respect to the statements that the defendant made, the trial prosecutor really tried to use these for consciousness of guilt, or tried to argue that they were consciousness of guilt evidence. But I would just ask you to look really carefully at the chronology of events when the officers arrived. And again, consider that there was no evidence as to the status of the relationship between the victim and the defendant, other than the fact that they were legally married. The Commonwealth didn't enter any evidence for even that he lived at the apartment. So when the officers arrive, they ask, when they see the defendant, they ask him, do you know where your wife is? And he says, no. So this, according to the Commonwealth, is highly suspicious, right? But again, we don't know if he had just arrived on the scene. Maybe he didn't even live there. Maybe he had just gone up to the apartment and knocked on the door, and she hadn't answered because she's in the neighbor's apartment. So he doesn't know where she is. So this doesn't really help them at all. And then the second statement, which has to do with when the victim was being brought out of the apartment and brought to the ambulance, the officer, he couldn't remember whether he asked the defendant or if this defendant spontaneously said that he had not been in an altercation with the victim that night. And the Commonwealth really tried to twist this unfairly in the closing argument. And in fact, on appeal, they don't do anything to try to correct it. It's very clear. If you look at the transcript, it's the August 8th, 2019 transcript at page 92. It's very clear that the officer asked this question as she was being brought out of the apartment and to the ambulance. But the Commonwealth tried to make it sound like a trial, that the officer asked him that question, or he said that as soon as he arrived on the scene. So of course, if the officer had arrived on the scene and the defendant right away had said, I don't know where my wife is, but I didn't get in a fight with her. Well, that would be pretty suspicious, right? Because how do you know you're not with the wife at the time? You don't know where she is. Of course, that would be very suspicious, but that's not what happened. Again, look at page 92 of the August 8th transcript, when the officer is testifying, it is very clear that that statement was made probably in response to a question that was asked by the officer as the victim is being brought to the ambulance. So of course, now the defendant can see the victim is injured.
Are you referring to officer? Are you referring to Officer Batantis? I don't know if I'm pronouncing it right.
Yes.
BANCES testimony. Okay.
Yes. Yes. So there's says something like, "Were you still with Mr. Toledo outside when the victim was brought out?" "Yes, I was." And and then what? Basically, and then what happened? Well, I can't remember if it was a question or if he said it, but he said he wasn't in an altercation with his wife.
Just going to forewarn you that you only have about 40, well, going down about 40 seconds left.
I just noticed that. Thank you, Your Honors. Other than that, I would just say, Your Honors, that that this was really, really thin circumstantial evidence. And it's important for the judge, like I said before, to act as a gatekeeper in these kinds of cases, that these kinds of cases don't go to the jury. Because, the results for this defendant, as you know, were 3 to 5 years of imprisonment on this extremely, extremely thin circumstantial evidence. So if there are no further questions, I'll rest on my brief for the remainder.
And I'll just check with the panel. I don't see anybody having any further questions. All right, thank you very much.
Thank you.
Now we'll hear from the Commonwealth, Attorney Mello.
May it please the court, Emily Mello on behalf of the Commonwealth. I'll start with the sufficiency of the evidence issue. The Commonwealth would argue that in this case, the evidence was sufficient as to the identity of the perpetrator and that the identity of the perpetrator was the defendant. Yes, the evidence was circumstantial, but as they say in Blackmer, it's not necessary that any one witness should distinctly swear that the defendant was the man. The evidence in support here would be that Ms. Aponte twice identified the attacker as her boyfriend, and the defendant, her husband, was the only unaccounted for male on scene when the police arrived within minutes of the 911 call. And at that time, he was intoxicated, as Ms. Aponte had described, and he also had bruising on his face. And as to the within minutes of the 911 call, the EMTs and the officers, I believe, all testified that they arrived within several minutes of the 911 call. And I think that it was a reasonable inference that Mr. Baroa and Mr. Valet, who both said that Ms. Aponte arrived at their apartment around 4 or 4:30, they were extremely reluctant witnesses. They also, Mr. Baroa testified that he heard the screaming, he got up, he went in the kitchen, he saw Ms. Aponte, then he went back in the bedroom and he called 911 and he went back to bed. So I think that there was a reasonable inference that they were mistaken about the time and that it actually happened shortly before 7 a.m. because then the police and the EMTs arrive several minutes later after they get the 911 call. I would point the court to Commonwealth v. Galicia, which is, not sure if I'm pronouncing that right, but 447 Mass 737, where the 911 caller identifies her husband as the perpetrator who'd beaten her. And when the police officers arrive on the scene within minutes, the defendant is the only adult male present and he has his shirt off. As to the excited utterances issue, of course, that's an abuse of discretion standard, and the judge was well within her discretion to resolve the conflict in the testimony the same way that the jury could, saying that assault happens, Ms. Aponte shows up, and Mr. Baroa is woken by the screams, calls 911, goes back to bed. Minutes later, police and EMTs show up. Those statements were made to the EMTs and they were made for the purpose or the primary purpose of medical treatment.
Can I ask you a question, Attorney Mill? I just want to, the judge makes the ruling and says, indicates that now, based on the testimony she's heard, that the defendant was in custody before Ms. Aponte was removed by was taken, transported from the apartment by ambulance. Is she correct? Is that your interpretation of the chronology of events at that with respect to the defendant's arrest?
That is correct, and obviously that evidence did not come out at trial because those were some of Ms. Aponte. I'm sorry?
It was at sidebar primarily?
Yes. So at sidebar, the prosecutor explains that the police show up, they speak to Ms. Aponte, she identifies the defendant as her attacker, they place him under arrest, and then the EMTs evaluate.
What do you mean by she identifies the defendant as her attacker? I don't recall the prosecutor saying that.
Yes, she identifies him by name. She says it was Cheyenne.
Was that
This is at sidebar, not in evidence.
I recall that. That was to Sergeant Lynch. Is that right?
Yes.
Okay. All right.
This was, I don't want the court to think that that was in evidence because it was
No.
not.
I realize that, but that was the basis of the judge's ruling with respect to whether or not these statements were made only for the purposes of medical treatment or whether or not they were also in aid of the investigation.
Absolutely. So what was said at sidebar and what the judge used to make her determination, the chronology is the police come, they speak to Ms. Aponte, they place Mr. Toledo under arrest, the EMTs evaluate her and bring her to the hospital. Those statements to the EMTs are the statements that are admitted. Once she's at the hospital, the police then interview her again. Obviously, none of the statements with respect to the police interviews are admitted in evidence. So the judge made the determination that based on the short amount of time, the fact that, she was bleeding, obviously injured, crying, that they were excited utterances and that they were non-testimonial because they were made for the primary purpose of the medical evaluation. There's significant case law to back that interpretation. And in any event, those same statements were admitted in the medical records.
So I was a little confused by that argument. Wouldn't we still need to, the records come in, but wouldn't we still need to evaluate the statements within the records?
Yes, absolutely. And so, but the argument at trial was, which was abandoned on appeal, was that the medical records shouldn't have come in at all under 79G, which obviously they do. And what would have been redacted are not her statements as to, I was hit, I was choked, I saw stars and passed out. What would have been redacted typically is that reference to the boyfriend. But that was not redacted at the request of the defendant because the defense was that there was a third party boyfriend who was responsible for the attack. So that was a strategic move on the part of the defense. And in any event, even if it had been redacted, it was still cumulative of Ms. Aponte's statements to Ms. Valet regarding that her boyfriend was the perpetrator. And if there are no other questions, I would rest on my brief.
All right, one moment, I'll check with the panel. Any further questions from the panel? I don't see any. All right, I have no further questions either. I want to thank you both very much. And on behalf of the panel, we wish you good health, stay safe, and stay healthy, okay?
5.
Okay, thank you very much. Good morning and welcome to the Appeals Court. And thank you for participating in the argument today remotely. Let me introduce the panel to you. I'm joined today by Justice Jeffrey Kinder and Justice Suk-Young Shin. My name is Ariane Vuono. Just a quick reminder that the same rules of appellate procedure apply in this format, which means you both have 15 minutes to make your case, and there is no rebuttal. It's Sometimes we have some technical difficulties as we go through the argument, and if we do, please be patient with us, and we'll be patient with you as well, okay? So let me call the next case, which is Commonwealth versus Angelo Gonzalez, 2019-1767. And we'll start with attorney, is it Vuono? How do you pronounce your name, sir?
Vuono.
Vuono, attorney Vuono, please begin.
Thank you, Justice Vuono and the court. If it please the court, again, my name is Joseph Vuono. I represent Mr. Gonzalez. I have quite a number of arguments in my brief. I don't know if I'll reach all of them, but let me start with the first one, which is deriving support from the earnings of a prostitute. The cases that I rely on, basically, the biggest case is the SJC case, Commonwealth versus Brown. And as I stated in my brief, the sine qua non, if you will, of that is you have to have the intent for the prostitution ring to occur. And my argument is that Angelo Gonzalez was a private contractor, if you will. He was supplying drugs to his brother, Elvin, and the other two gentlemen who were also involved in the prostitution ring. Angelo was never involved in the prostitution ring as a member. He didn't start it. He didn't keep it going. He didn't intend for it to occur. And as I argued in my brief, I see Angelo as no different in what he was doing than what the pizza delivery guy was doing across the street. They both had a product. One is obviously legal, pizza, and drugs are obviously not legal, but they were both supplying a product to a prostitution ring, and they were getting profit from it. The
But it was a
same
little,
could be
little
said
different
for
here, isn't it, sir? Isn't it just slightly different in the sense that the drugs are being used by the perpetrators of that prostitution ring to keep the women that were working for them to entice them, so to speak, to keep them going, and that was what really kept them within the illegal conduct to begin with. Okay, so I think we're frozen. All right, I see both attorneys as frozen. How about Kinder, you're not, Shin, you're not.
I think we only have
I think we,
one.
all right, so I think we lost Attorney Vuono for a moment. Let's see if we can get him back in.
So we were at about the 13-minute mark, I think,
Okay, thank you.
roughly.
Kristen, I don't know if you can hear us from here.
Yes, I can. Thank you.
That's perfectly understandable given the situation. So why don't you go ahead and continue starting now.
Okay. Should I start?
Sure, please do.
Okay. As when I left off, I was in the midst of answering Justice Vuono's question, and again, the girls have to eat, so they have to get food from the pizza delivery man. If they don't eat, they can't do what they do. The same argument could be made if they contracted some sort of an infectious disease and they had to go to see a doctor. Again, the doctor has to give them his product in order for that prostitution ring to keep on going. And again, that's the same with Angelo Gonzalez. He is a private contractor who is supplying a product, drugs, to these women, without which they would not be able to do what they do. And so the other point is, like the doctor who supplies his services to everyone in the community, Angelo Gonzalez sells drugs to anybody in the community, not just that prostitution ring. So he's no different than the doctor or the pizza parlor shop owner who delivers his product to anyone who comes in and decides to purchase it. So in that regard, he is no different than anybody else. In that regard, he is not intending for the operation to occur. If he was intending it to occur, he would have been one of the initial signatories to the deal, but he wasn't. It was his brother Elvin. It was Taylor Ritter and Brad Alberini. Those were the guys that started this ring, and none of the women ever got any money from Angelo directly. They never got drugs from Angelo directly. He was rarely there, as if you look at the testimony of Ms. Powers, who testified at the trial. So in that regard, he did not intend for the prostitution ring to occur.
Attorney Fasson, what do we do with the evidence that the defendant, at least if it's believed, participated by transporting one of the women to a so-called out call?
Well, I would direct the court's attention to the case I cited in my brief under the trafficking, and it applies, actually it's a deriving support case, Commonwealth versus Fetonia, where the defendant was routinely driving her friend to dates. She knew what her friend was doing, and on occasion she would be reimbursed for gasoline money to drive her friend there. And yet the court said, she's not a pimp. That's not what the statute is trying to address. We're trying to address people who do this as a living. They intend for the operation to occur. And so if the defendant in Fetonia is not guilty, then for giving multiple rides and getting something in return, Angelo Gonzalez cannot be guilty of giving, arguably, Brittany Harvey, or it was Miss O'Brien. They weren't really sure at trial. Mr. Alberini wasn't sure at trial which one it was. But giving that one ride, and there is no evidence whatsoever in the record that he took money in exchange for giving this woman a ride. The record does contain information that the only person who had an automobile at the time, excuse me, was Angelo Gonzalez. So, one ride does not make a trafficker. Again, on the trafficking charge, there were 5 counts of trafficking. The jury acquitted of him of 4, but only found him guilty of trafficking with regard to Brittany Harvey. And so why is that? I mean, the only logical explanation is because Alberini testified that he gave this woman a ride to a date, and transportation under the trafficking statute, is prohibited. And so that's why he was, I believe, convicted of trafficking in Miss Harvey, because he gave her that one ride. But again, as I said, if under Fetonia, if the statutes are not designed to go after people like, the defendant in Fetonia who gave multiple rides, then it certainly should not apply to Angelo, who at most gave this woman one ride and didn't take a nickel for it. And so I would move on to my next argument, which is the argument on whether or not gang membership, the motion to eliminate to include gang membership to support a joint theory, should have been allowed. And as I said in my brief, it shouldn't have. It was put in there mainly to make Angelo Gonzalez look bad as being a member of the Kilby Street gang. Now, the prosecutor's argument was, well, if you're a member of the Kilby Street gang, then somehow you have access to the profits of another Kilby Street gang member, which would be his brother. Well, that doesn't make any sense, because Fabian Beltran, who was another co-defendant, at one point, I believe, took Miss Harvey over to his operation, and she was working for Mr. Beltran. And Mr. Beltran was also, without question, a Kilby member. And yet, without question, Mr. Beltran's business dealings were adverse to Elvin Gonzalez's business dealings. So how can you say that because they're both Kilby members, Elvin was a Kilby member, Beltran was a Kilby member, their economic interests are adverse to each other, and yet the prosecutor is trying to say because Angelo and may be a Kilby member, there was no definitive evidence that said he was a Kilby member. Therefore, because he might be a Kilby member, he's part of a joint venture. the case that I mentioned in my brief, Bannister, kind of highlights this. In Bannister, during the hearing, the police officer was qualified as an expert witness. He knew gangs, and he said, "Here's why, this gang membership and this joint venture theory are applicable," and they gave reasons. In Mr. Gonzalez's case, there was no evidence adduced during the motion in limine to explain why being a member of a gang, Kilby gang, automatically satisfies all the elements of a joint venture. It doesn't. There was absolutely no evidence whatsoever. And
wasn't the issue of gang membership in Bannister offered for a slightly different reason? That is to show motive.
It was, but yes, it was. But you still have to have some explanation from somebody with knowledge, which was the Boston police officer, of what these gangs are. His testimony was that these gangs are adverse to each other. These two guys hate each other, and that would explain why what happened. But at our trial, Mr. Gonzalez's trial, there was no expert witnesses to testify why, if you're a member of a Kilby gang, you're automatically a joint venturer with every other Kilby gang member. It doesn't make any sense. The other thing is, if you wanted to show an association between Angelo Gonzalez and Elvin, they were brothers. The jury knew without any question whatsoever that Elvin Gonzalez and Angelo Gonzalez were brothers. So there's your association. To interject this gang business into the equation just sullies Mr. Gonzalez's reputation in the eyes of the jury, and it was highly prejudicial. And I don't believe that for that reason it should have come in. The other argument I made was that in the midst of the trial, Miss Powers, who was a witness for the Commonwealth, testified that just about everything she testified to at trial was information that she did not have firsthand. She got it from her boyfriend, Elvin, who was the defendant's brother. Okay, Elvin was an unavailable witness under the Crawford elements. He hadn't been tried yet, so he couldn't come to court. And in closing argument, even the prosecutor admitted to the jury that Ms. Powers' testimony was hearsay. And although this wasn't the classic per se under Crawford, where you have somebody talking to a police officer and the person should realize that this is going to go in front of a jury because you're telling a police officer. In this case, based on what she was telling everybody, based on what she was telling the prosecutor, she certainly knew that she was going to have to talk about this at a criminal proceeding. So, as I said in my brief, under Crawford, my client was prejudiced because he wasn't able to cross-examine his brother, Elvin, as to what was going on. Because, again, all the information that was given...
There was no motion to strike made below, and it's unclear to me now what testimony you're saying should have been stricken. The entirety of her testimony?
Yes, because during her testimony, in fact, the co-defendant who was being tried jointly with Mr. Gonzalez, his lawyer, stood up and objected, and he moved to strike all of her testimony because everything that she said, she says, I got all this information from Elvin. Elvin told me all this. Okay, there was some testimony where she made her own visual observations, like when she said, well, Angelo wasn't over here, Angelo wasn't here, Angelo showed up once over here, I never saw Angelo giving drugs to anybody, things of that sort. But the rest of it, the highly prejudicial stuff which she testified to, I mean, she was an important witness. I mean, they gave her a cooperation agreement, so they wouldn't have done that if they didn't think she had something very damning to say about Angelo Gonzalez. And so, that being the case, her testimony was crucial. And my client didn't have enough.
I'm going to interrupt you for a moment, Attorney Pisoni, unless Justice Shin has some follow-up questions for you with respect to that that issue. I want to direct your attention, if I could, to the issue involving the argument you make that your client or trial counsel was not permitted to exercise a peremptory challenge to juror number 48.
Right. Well, that woman, juror number 48, she testified that, well, when she was voir dire, she stated that she was well aware of the Kilby Street gang operation, and that I believe she had a member of the family who was a police officer, and she was challenged, and the judge said, no, I'm not going to allow you to exercise a challenge on that. And that's highly prejudicial because, again, you have this woman knowing what Kilby Street gang is all about, okay? And what she knows about Kilby Street obviously was not gotten from the testimony and the exhibits that were presented at that trial. She had past history of growing up in the area of Worcester where Kilby Street gang was prevalent.
Right,
And,
but the judge did indicate that he was not allowing the challenge in part anyway, because she was a member of a protected group, right?
Yes, she was not right, but her ethnic background has absolutely nothing to do with it. I mean, what does her ethnic background have to do with anything? She says, I know what Kilby Street is. I know they're bad guys. Okay? She grew up in the Kilby Street area. She says, I know these guys are bad guys. Okay? So if you look at all the questions she was asked, it's highly prejudicial. Okay? Notwithstanding the fact that she's a member of a protected group. That's completely irrelevant in the context of what we have here. They weren't striking her because she was a member of a minority group. They were striking her because of the Kilby connection and everything she said.
Attorney Desson, you say it was highly prejudicial. How can we go about assessing prejudice in this situation?
With a juror?
Just in this precise situation.
I'm losing the sound.
What is the prejudice analysis in this precise situation?
Okay, the prejudice analysis is that, you have a person who is familiar with Kilby, knows they're bad, okay? And then when she goes to decide guilt or innocence, and then you have evidence adduced at trial that Angelo Gonzalez is a Kilby member, his brother's a Kilby member, and because they're Kilby members, that links them together, via the joint venture theory of the case. And that makes him guilty of trafficking and makes him guilty of deriving support, okay, simply because he's a Kilby guy.
But isn't that akin to saying she should have been struck for cause?
Well, yes, I would say she should have been struck for cause. Yeah, that's definitely.
There was no challenge made for cause here, so it's a little. I'm just not sure how we assess prejudice.
Also, too, Your Honor, is that not only the Kilby Street, but she was also related to two police officers, Worcester police officers.
Two cousins.
Okay. If she was related to two Worcester police. Well, cousins, they weren't her brothers, but, she was related to them, and she knew the reputation of Kilby. And she also said she had a hard time with the concept of reasonable doubt and the defendant's right not to testify. She also said she had a problem with that. I mean, that's
right.
That
so following up,
Attorney
Desson, following up on Justice Shin's question then, in terms of trying to analyze the prejudice. So your point in your brief is that by in the manner in which these questions were answered during voir dire shows bias on the part of this juror. So is it all right? So do you have to? So is it your position that all you have to show is that the judge abuses discretion by not allowing the peremptory challenge, or what?
Yes,
where's the critical juncture that we need to analyze? At what point do we need to analyze this?
I think the analysis begins and ends with her responses about Kilby's no good. I've got cops as relatives, although that could go either way. And I have a problem with reasonable doubt. And, I got a problem if the defendant doesn't testify, then he must be guilty. Why wouldn't he testify and save himself? So
But she
all of
did
that
answer,
stuff.
her answer to that question was she can remain impartial. Let me just ask you quickly one more question, because I know we're keeping you over your time. And that is,
Okay.
should we determine that that the judge was acting appropriately because this particular juror was a member of a protected class, and everyone seemed to have agreed at trial that she was Hispanic. That wasn't disputed. It appears to me. Then what is your response to that? Would you think
Well,
that you would need to have?
I'm sorry. Yeah. My response to that, Judge, is basically that she's Hispanic, but so isn't Gonzalez. He's Hispanic. Both defendants are also members of the same class she's a member of. So how can you say that she would, that just because she's a member of this class, she's not going to be biased? It just doesn't make any sense. I mean, her membership in a protected class, is irrelevant. The only thing is relevant is her responses. The responses that she made to the questions and whether or not those responses indicate that she's going to be a fair and balanced, objective decider of the fact.
I think I understand your position, and I appreciate you asking those questions. Your time is up, but I'm going to check with the panel members to see if they have any other questions they want to ask about any of the other issues.
Okay.
I'm seeing none. Okay, thank you very much, Attorney Bisson. Just stay on the phone so you can hear the argument presented by Attorney. Is it Bodine or Bowden? How do you pronounce your names there?
It's Bodwin, Your Honor.
Bodwin. Okay, Attorney Bodwin, please.
Good morning, Your Honors. Nathaniel Bodwin for the Commonwealth. I will first address the defendant's first claim about the sufficiency of the evidence in terms of deriving support from prostitution. In the light most favorable to the Commonwealth, the evidence was sufficient here. In order to convict a defendant for that charge, the Commonwealth has to show that an individual was a prostitute. I don't think that's at issue here. They have to show that the defendant knew an individual was a prostitute and that the defendant shared in some way in the proceeds from that individual's prostitution. I think when you look at the totality of the evidence here, yes, the defendant primarily supplied crack cocaine to this operation. As Justice Vuono pointed out, these were all women who were dealing with substance use disorder, who were heavily addicted. The two women who testified, one mentioned that she stayed in this operation because she had been homeless before. The other woman testified that being a part of this operation provided her a stable place to stay. So keeping these women addicted to various drugs was a key and integral part of this operation. But not only that, you have evidence that the defendant actually on one occasion rented a hotel room for purposes of prostitution. We heard evidence that he provided a ride for one of the outcalls to one of the women. You had just on one occasion, Victoria Power was asked, when Elvin Gonzalez, the defendant's brother, wasn't able to go to the hotel and provide the women drugs or collect money, did the defendant, who else did that? And she responded that sometimes the defendant did that. So again, that's testimony that he actually went there and directly supplied the drugs to the women, directly took money from the women for those drugs. And he was also, based on the testimony of Brad Alberini, he knew about the management of the operation. He gave some insights as to perhaps what he didn't like, what was going on with the operation. And I believe Attorney Vizone pointed out that, yes, Victoria Power testified that she only saw the defendant there on one occasion. However, you had Brad Alberini testify that during the time of this operation, he saw Angelo Gonzalez, the defendant, there on an almost daily basis. And that on most occasions, he was outside of the hotel room, but on at least 5 occasions, he was inside that hotel suite where the commercial sexual activity was occurring. And there was testimony that no one there was hiding what was going on, that he was there when there was discussions going on about the woman trying to seek new, quote, dates, and about needing the bedroom for the purpose of those dates. So I think that all of that testimony together shows certainly he knew that prostitution was occurring and that he was certainly benefiting financially from that operation. In terms of the second issue brought up by Attorney Vizone in terms of gang membership.
Before you move on, counsel, I did have one question on sufficiency. In your brief, you say that there is evidence that the defendant occasionally provided the drugs directly to the women and occasionally collected the money directly. I was unable to find that in the evidence, other than perhaps it was Power's testimony, which she said was based on, the issue with what it was based on what Elvin had told her. So did I miss it somewhere else?
I'm referring to transcript 4, page 108 to 109. Where I believe it was on redirect that
Whose
she was
testimony is that?
Victoria Power, Your Honor.
Oh, okay.
So transcript 4, page 108. And I, as I said in the brief, that was not anything that was argued by the prosecutor in closing. That was not emphasized enough. But I think since the jury heard that testimony, that also shows that he was very much involved more than just
Right, but isn't that testimony based on what she's saying she heard from Elvin?
Honestly,
because the defense counsel was allowed to recross her, and he elicited that the only thing she knew directly with respect to the defendant is that he was in the hotel room once. I believe that was her testimony. So shouldn't we conclude that the rest of the testimony is based on what Elvin told her?
to be honest, Your Honor, I don't recall exactly whether that was the testimony where she said she heard directly from Elvin Gonzalez. So.
Okay.
And then in terms of the issue about gang affiliation, the judge properly denied the defendant's motion in limine, and the judge acted properly here. Each juror was asked during the voir dire about that gang membership was going to be an issue here, whether they could be fair and impartial with people who were involved in gangs. The judge also properly gave a limiting instruction that this was being introduced only for purposes to show that there was a common enterprise going on here. He provided in that instruction, he instructed the jurors not to draw any adverse inference in terms of that gang evidence. So, and courts have repeatedly said that evidence of gang membership is admissible to show both motive or joint venture. In terms of the sufficiency of the human trafficking charge, again, the same evidence that I discussed in terms of deriving support for prostitution, that was sufficient also to convict the defendant for human trafficking.
Can I ask you a question related to jury selection? I might be jumping forward a little bit, but as you know, biases in favor of law enforcement and against gangs are often bases of peremptory challenges. Where can we look in the record here for support for the judge's conclusion that in fact the challenge here was race-based rather than on one of those biases?
Well, I think the judge pointed out that the juror number 48 was Hispanic, that it was defense counsel who asked the juror of the voir dire to be the veneer to be asked questions about ethnicity. That was clearly an issue that the defendant wanted to be discussed. And the case law does say judges sua sponte can seek further explanation for a peremptory challenge, especially when the challenged juror may be a member of a protected class. And I did say, and it wasn't made explicit, certainly, but I think it was perhaps somewhat implied that this juror may have been the only Hispanic member of the veneer. It's not clear, but there was some suggestion that they were. And I think a judge is allowed to bring that up. I think they're encouraged to seek further explanation when peremptory challenges are made. And the fact that, and I think also implied in the judge's ruling was that he didn't find the explanations for the challenge to be either adequate or genuine, because as was discussed earlier, the juror made clear that despite relatives or the cousins being police officers, despite her knowledge of the Kilby Street gang, she could still be fair and impartial as to those issues.
And was there anything else in the record that would have supported a conclusion that because the juror was Hispanic, she would tend to favor the Commonwealth?
Nothing clear about that.
So you said there was a suggestion, I'm sorry, Judge Vuono.
No, go ahead, please go ahead.
You said there was a suggestion that she was the only Hispanic member of the veneer. Where can we find that in the record?
I don't have it in front. I believe it was implied by nothing clear. I think it was implied by what I read that the judge did have a concern about that she may have been the only. It wasn't clear. I believe it was implied.
So I want, actually, Justice Shin brought up an issue that precisely what I was just thinking about, which is, do we need to know more about the veneer in order to evaluate the propriety of the judge's decision here?
I don't believe so, because I think the issue was, did the judge find the explanation from defense counsel to be adequate and genuine? And I think he did not find it to be. And
well, how do we review that? In other words, how do we evaluate the judge's decision, whether or not the decision was adequate and or genuine? Do we review that for abuse of discretion?
I believe you do, yes.
Because in this case, there was significant evidence of the juror's involvement with law enforcement. She worked herself as a security guard, wore a uniform, and considered her current job to be a stepping stone to become a police officer. Perhaps following inferably in the steps of her two cousins who were already police officers. So, I mean, that's a fairly strong affinity, if we put it that way, for law enforcement. Would you agree with me on that? So, if we were to find that was the case, and if we were to be skeptical, again, of the judge's finding there, wouldn't it be important for us to know about the constitution of the rest of the veneer?
Well, again, I think that despite, I understand everything you're saying, Judge, but despite the relationships, despite her current job, despite the family relationships with police, she still was able to say she would be fair and impartial towards anyone who was involved in a gang, or she would be fair and impartial regardless of whether it was a police officer testimony or a civilian testimony. But yes, I mean, but I do say there is nothing clear here about the actual constitution of the jury in terms of how many people were Hispanic, how many people were not. But but the ethnicity of juror number 48, the judge clearly pointed that out. No one disagreed that she wasn't Hispanic. The defendant is the one who wanted these questions about race and ethnicity asked to the veneer. And I think
I think what I'm struggling with is that the reasons given seem to me to be adequate to exercise a peremptory. So, I mean, the real question is, did the judge find that it wasn't genuine in the sense that the challenge was being exercised because of the juror's ethnicity? And I think you're asking us to infer that based on the defense counsel asking from the get-go that these questions be asked and that she was Hispanic. And so, I mean, can you point us to anything else that shows that these explanations weren't genuine as opposed to adequate, inadequate?
I think the judge here did not clearly state whether he found the reasons for the challenge to be adequate or genuine. We don't have that here. So I can only argue what was implied in terms of what he said. So I can't point you to anything specific.
So I'll ask you the same question I asked your brother. Assuming that the judge erred, how do we analyze prejudice in this situation?
I believe I'm not exactly sure the standard of how if you were to find this was done in error, but again, I think in terms of both of these issues, yeah, what did the judge? I guess it would be an abuse of. I think it would be an abuse of discretion. Did the judge adequately find that the juror could be fair and impartial? Was that an abuse of discretion in terms of finding that, and whether he properly denied the peremptory challenge?
And what would the remedy be if we were determined that the judge erred in this respect? What would the remedy be?
I mean, again, I think that's a high standard to meet, and I don't believe the judge did abuse his discretion here.
No, I understand that. I'm just asking you hypothetically, what would happen next?
Hypothetically, I can't say for you here. I'm aware of what the case law says about what needs to be done in terms of if you did find the judge erred here. So I don't want to say anything on the record.
Okay.
That would be inaccurate, whether it helps me or hurts me. Yeah. And if your honors have no further questions, I'd be glad to rest on my brief.
Any further questions? I see no questions from the panel. I want to thank you both very much. Thank you for bearing with us with respect to the difficulties we had with Attorney Vuono. We appreciate you answering all of our questions. We'll take the case under advisement. And meanwhile, on behalf of the panel, we hope that you all stay safe and healthy during these challenging times that we're.
And we are live.
Okay, good morning to you all, and welcome to today's sitting of the Appeals Court remotely. Let me introduce the panel to you. I'm joined today by Justice Jeffrey Kinder and Justice Suk-Young Shin. My name is Ariane Vuono. Just a quick reminder before we begin, the same rules of appellate procedure apply on this platform. You each have 15 minutes to make your argument, and there is no rebuttal. You can be assured that we've reviewed everything that you have submitted to us before today. If we have any technological difficulties, please bear with us and we will bear with you. Let's hope that doesn't happen, but if so, we will take care of it and move on. So I'm now call the case, Commonwealth versus John Byers, 2018-1453, and Attorney Nam Crane.
Yes, good morning, Your Honors. May it please the court, Michael Nam Crane for Mr. Byers. I'm going to talk about the jury instruction first. And I think we're all familiar with the Fay and Suave cases at this point. And I would submit that the failure to instruct the jury to consider whether Mr. Byers stalked, lured, approached, confined, or touched the victims denuded his defense and allowed the case to go to the jury without the necessary legal guidance. If you look at both the Fay and the Suave cases, though they defined what is necessary to find somebody sexually dangerous, being, that apprehension of sexual touching, particularly for children. The court does talk about the sort of behaviors that guided them. Literally, they use that language. They say in Fay, influence their decision. These behaviors influence their decision in deciding whether or not that evidence was sufficient. And so that's—
Mr. Nam Crane, can I interject a question?
Please.
Is there anything, at least I didn't see anything, in the model Superior Court jury instruction with respect to menace that included the language that you suggest? So why was it an error for the judge to basically follow the model instruction?
Well, I think after the recent Dunphy case and the SJC just decided very recently, I think we should all know this just from our own practices, is that you should never rely on the model jury instructions as to what the state of the law and particularly any particular case should be. As practitioners, we must always look at the treatises and the model jury instructions and then review our own, understanding of what the law is and what our case is. And so in this situation, and given the case law, I think that this language was particularly in this case was necessary to guide the jury as to what and the Commonwealth uses this language when it asks for this instructions. It said this instruction will help guide the decision, and they characterize it as guidance to the jury. And I can't agree with that more strongly. That in this situation where you have an individual who doesn't exhibit, the behaviors that Mr. Fay exhibited, who is really purely a non-contact offender, and we have to decide whether or not he's a menace, then this language is what the SJC has, relied on in determining that, and it should not be ignored. And it was really necessary, particularly in this case, to give the jury the idea of what menacing behavior is.
Okay, let me follow up on that. Assume for the moment that we agree that language, the questioned language in this case, should now be a part of the model instruction. In this particular case, there was evidence, at least, that the defendant approached and perhaps lured young children. Given the fact that there was that evidence, why would it be a strategic or an unreasonable strategic request to object to the use of that language in this particular case?
A couple of things on that, Your Honor. For one, I sort of would disagree with the premise of the question in the sense that whether or not these are sort of how this particular defendant, Mr. Byers, exhibited that quote unquote behavior, and whether that was menacing in his context is arguable. And I think it's important to look at the fact that the SJC talks about these behaviors, together, usually brings them, talks about them in a string as to what, it doesn't just say luring or doesn't just say approaching, but uses, a number of these behaviors together because they have to be looked at collectively. And so whether and I think and the other thing too is there's a disagreement in this case as to whether he in fact did any of these behaviors in a menacing way. I think Dr. Johnson, who was the other QE, and Dr. Plaud particularly, the way they characterized what his behaviors was to facilitate his exposure and not as the menacing behavior under the statute. And so, I think when you have to sort of, I think your question becomes apparent when you look at the defense counsel's argument. She talks in her argument, she starts to say Mr. Byers never held back any child or prevented a child from leaving or did any of these things. And she stops, she makes a full stop. And I think you can read there where she realizes she didn't ask for this instruction. So now she can't continue this argument that she's making. And she just says, and there's no evidence that he's a menace. And she makes a full stop because she realizes rhetorically she's getting into that language. And I think that it makes you realize that, hey, there is an argument about this behavior and whether he did it in, vis-a-vis being a menace. And
in light of trial counsel's affidavit, is there any dispute in your mind that her objection to the instruction was strategic in nature?
Well, I mean, the question is, I think it was. I mean, I know Sandra Schmidt very well, and I take her at the word that it was a strategic decision. The question is, was it manifestly reasonable? And I think that as much as she's experienced in these cases, she had only done about 2 of these suave fay type cases prior to this, and I think the significance of that language may still have been sort of fluid out there as far as how do we read what the SJC intends. And so I think she really misread this case. I mean, obviously you want to be worried about whether this behavior is present in your case, but then again, she had experts on her side, including a qualified examiner who was telling the jury, yes, he approached, but this was to facilitate non-menacing behavior. They had explanations for all his behaviors and to find it non-menacing. She had not only her own expert, Dr. Plaud and Dr. Bard, but she had a qualified examiner who was on her side, who was telling the jury why these behaviors did not amount to menace. And I think it's important because all the experts, that testified as forensic experts to the issue of sexual dangerousness they all use the fe suave language in their analysis. And so the jury is no.
Let me, while you're talking about experts, let me move forward a little bit.
Yes.
To the fact that this case, as we all know, involved conflicting testimony and opinions from various experts.
Right.
But if we view the expert testimony in the light most favorable to the Commonwealth, and Dr. Rouse Ware testified that in fact the conduct would instill fear in children if it continued, why isn't that in and of itself enough for a sufficiency argument?
Well, that's a good question, Your Honor. I think, you know, I looked at sort of the case law that's come out more recently, and there's an unpublished case called, where is it? I just had it. Forgive me, the Tiro case that came out in 2019. And it's interesting because Rouse Ware talks about it in footnote 2 in the Tiro case, again, it's 16-P-1520. She talks about how that she actually did some empirical research on her own, where she interviewed children. And 90% of the children told her that masturbating in front of them would make them in fear of being sexually contacted. She testified to this in 2012. She doesn't mention this empirical research in the 2018 trial Mr. Byers had for some reason, very interestingly. And so, you know,
but don't we have to judge our sufficiency on what was before the jury, not what was absent?
No, you're right, Your Honor, absolutely right. And so in this case, with Mr. Byers' case, you know, whether her opinion is sufficient, you know, that's just her opinion. The jury, you know, can take it or leave it. And whether that opinion alone amounts to sufficiency, what you have to ask is, do the underlying facts of this case support that opinion? You know, just like any expert, you have to evaluate their opinion by the underlying facts. They can't make it up whole cloth. And in this case, where you have, Dr. Rouse Ware saying that he was not aggressive. The guy's supposed to be a menace and he's not aggressive. That, you know, that's doubt alone. Dr. Bell admits that children may not have been afraid of him, beyond just being exposed. They may very well not have been afraid of being sexually contacted. He's never touched anybody. No one's accusing him of escalating his behavior. You know, I mean, the experts talk about this behavior not being directed at sort of sexual. At least the defense expert, Dr. Johnson and Dr. Plott, they talk about he exposes himself to children, not because he's necessarily attracted to children, but because he gets a better reaction from them vis-a-vis his exhibitionism. And both those doctors explain the phenomenon of exhibitionism. And Dr. Plott actually has treated exhibitionists. And so you have all these, these experts talking about how he's not aggressive, he doesn't touch, he's not escalating. So where is the sufficiency of this evidence to believe that he's actually a statutory menace? And and this menace has to get over the substantive due process mountain, really, for the state to commit this person under substantive due process, both the federal and state due process clauses. We're going to lock this guy up for life because he's a menace. So what does menace mean? That has to have a lot of weight. That particular type of menace has to have a lot of weight. And when you have a person who the state's expert says is not aggressive, he's not escalating, he's never touched anybody, how is that menacing behavior? How is that sufficient evidence? This is not the kind of behavior that Mr. Fay or other defendants exhibited where they actually had touched children or something like that. This is purely exhibitionist behavior. And
the question for the jury would be then, will that behavior, if it continues, instill fear in the children of a contact sex offense? And there's at least one opinion stating the answer to that question is yes.
Well, yes, and Dr. Rouse, that's Dr. Rouse Ware's opinion. But like I said, is that opinion supported by the underlying facts? Is this person exhibiting the sort of guiding behaviors she talked about that influence their decision, to find Mr. Fay sexually dangerous? And we would argue that, we would agree with Dr. Johnson and Dr. Plott that his behaviors do not amount to a statutory menace. And that Dr. Rouse's weird opinion about what children, that's her opinion. But does the facts support that? Do the facts reach that beyond a reasonable doubt? No, we would say no. They were sufficient for that. And so you just went into my sufficiency argument. I appreciate that, Your Honor. Again, I would just say that, when these type of cases, right now the model and jury instruction talks about, the child's apprehension and things like that. But I think we can't ignore the fact that the SJC in at least two of its seminal cases and looking at this very unique part of of our STP jurisprudence talk about these behaviors and that and these behaviors guide them, they influence them. And the Commonwealth in their instruction argument they agree with the SJC that these are guiding behaviors, and that, if that instruction in this case may have actually harmed the Commonwealth. So, whether the judge was right in her motion for new trial to find that Mrs. Schmidt was not manifestly unreasonable in her decision to omit that language, I think it was just plainly wrong. I think it was manifestly unreasonable, given the case that Mrs. Schmidt had in hand. With this, we have a guy who is not actually touching anybody. He's not escalating. He's not aggressive. And when the SJC itself is again and again talking about these behaviors as what should guide a fact finder and how we decide whether a person is a menace in this particular scenario. If there's no other questions, I'll stop there. Thank you.
Thank you very much. I see no questions, and so we'll return the argument now over to Attorney Cusick.
Good morning, Your Honors. May it please the court, Tracy Cusick for the Commonwealth. Your Honors, the Commonwealth asked this court to affirm the finding that the respondent, Mr. Byers, is a sexually dangerous person. The evidence was sufficient here to find he was a menace within the meaning of the statute, and also the jury instructions that were given were correct, thorough, and he was entitled to no more. They did not create a substantial risk of a miscarriage of justice. The Commonwealth submitted a written request for jury instructions, and it was in fact patterned on the 2013 model jury instructions, and the Commonwealth included language from the Fay case in there relative to non-contact offenders. The model instructions were updated in 2018. It doesn't appear that the court actually had access to them at the time of this trial. But looking at what the updated model instruction shows, this language that the respondent now says should have been given is not contained in that instruction. So certainly if those instructions had been the model, the respondent would not have been entitled, at least in the model.
Would you agree, Ms. Cusick, that in light of Fay and Suave, that the instruction that the Commonwealth proposed would have been a more complete instruction and offered more guidance to the jury?
Your Honor, it would have been more information, but as the Commonwealth also acknowledged it during the discussion of the instructions, it could have cut both ways. So certainly had there been no objection, had the instruction been given, I suggest we would have received the same result, that this respondent would have been found sexually dangerous. But here, the respondent's attorney objected to it for strategic reasons, given the evidence in the case that the respondent had targeted children, and there's evidence that could be construed by the jury as luring, stalking of the children. So I suggest it was a reasonable strategic decision to oppose the giving of that instruction. And certainly it was discussed on the record with the judge why counsel was doing that. And then in counsel's affidavit submitted in conjunction with the motion for new trial, counsel says, well, in hindsight, it might have been beneficial, but also one can construe from that, it might not have been. Again, we know what the result is based on the instruction that was given. And I suggest that the respondent was not entitled to the additional language to which he opposed. And Your Honors, with respect to the sufficiency argument, again, it was for the jury to decide whether the respondent was a menace. They had the opinion of one qualified examiner and an independent expert, Dr. Bell, that he was not, that he was, and of the respondents' experts that he was not. And they had the evidence of what his behaviors had been. And certainly here.
And what, Ms. Cusick, what do you say to Mr. Nam Crane's argument that the opinion upon which the Commonwealth relies, and that is Dr. Rouse Ware's opinion regarding instilling fear of contact offenses in the future. How do you respond to his argument that that opinion was really offered in a vacuum without any supporting evidentiary or scientific basis?
Well, Your Honors, I disagree with it, not that it was in a vacuum or without any basis here. Certainly, counsel's correct. The evidence that counsel cites from a different case was apparently not part of this case, but certainly the doctor is an experienced, I believe, psychologist, had ample training, and looking at the facts determined that this would instill fear of a contact offense in children. And in addition to that opinion, the jury also had the facts of what this respondent had done previously, and they could determine whether this would instill fear in future contact offenses in children.
So do you think that the evidence would have been sufficient even without the opinion of Dr. Rouse Ware?
Your Honor, I believe it would have been, but I also know that in these cases, the Commonwealth does need the opinion of an expert qualified examiner to proceed. But if putting all of that aside, the jurors could have independently reached that conclusion without that expert opinion in this case, because they had ample evidence to determine that this respondent's activities, his predicted activities, would be likely to instill fear of a contact offense in prospective child victims. And certainly the respondent had evidence perhaps of what his intentions were or what he intended by that behavior, but looking at this from the perspective of the child victim, his predicted behavior would be likely to instill fear of a future contact offense. If there were no further questions, the Commonwealth would rest on its brief and ask that this court affirm the finding that this respondent is a sexually dangerous person and affirm the denial of the motion for new trial.
Okay, I'm looking, I don't see any further questions from the panel. So thank you very much. Thank you both very much for your arguments. We'll take the case under advisement. I can answer back to you as soon as we can. Meanwhile, on behalf of the panel, we hope that you and your families stay safe and healthy during the what will hopefully be a pandemic that ends soon. But for now, please take all precautions.
And we are live.
Okay, good morning. I think we're still morning. Yes, we are. Good morning. Welcome to the Appeals Court, and thank you for participating in the oral argument today in this remote platform. The panel today consists of myself, Ariane Vuono. I'm joined by Justice Jeffrey Kinder and Justice Suk-Young Shin. Just a reminder that the same rules of appellate procedure apply in this forum, which means you each have 15 minutes for your argument, and there is no rebuttal. You can be assured that we've read everything that you provide to us thus far, and so we're ready to hear your argument. I'm going to call the case, Springfield Rescue Mission versus the Board of Assessors of the City of Springfield, 2019-1629, and Attorney Ambriano, you're first.
Thank you. May it please the court, Anthony Ambriano for the Board of Assessors of the City of Springfield. This case is an appeal from a decision of the Appellate Tax Board. In that decision, the Appellate Tax Board granted a property tax exemption on the basis of General Law, Chapter 59, Section 5, Clause 11, as a house of religious worship to a property that was owned as of January 1, 2015, the assessment date for fiscal year 2016, by a subsidiary of the MGM Casino in Springfield. And that same entity owned the property as of July 1, 2015, the date for determination of property tax exemptions under General Law, Chapter 59, Section 5. And in fact, that for-profit entity owned the property for 1/3 of fiscal year 2016. The case has a somewhat unusual procedural history. The case was tried at the Appellate Tax Board on the basis of the taxpayer's claims that its property was overvalued. And by the taxpayer, I mean the Springfield Rescue Mission, not Blue Tarp, the MGM subsidiary. The Appellate Tax Board, on its own motion at the conclusion of that hearing, raised the issue of exemption and issued a decision exempting the property on the grounds that it was under Clause 3rd, not Clause 11th, but under Clause 3rd, as it was in fact a charity.
No, I just was saying as a chair. But then the hearing was reopened on your motion, correct?
Now that is correct. There was a motion to reconsider, and then thereafter the motion to reconsider was allowed for limited purposes, and a hearing ultimately was heard on the issue of exemption.
And I just want to ask you a question about that hearing, because I think that you indicate that the taxpayer, that is the mission, that there was testimony at that hearing. Can you help me out there? It seemed to me that there was just argument at that hearing and that documents were provided, in particular the purchase and sale agreement for the Appellate Tax Board to consider. But am I missing something? Was it, I don't recall if there was that the two individuals representing the mission were sworn in or anything of that nature.
I do not recall them being sworn in at the reopened hearing. I was not present at the valuation hearing, but I would think that under the board's common in practice, they would have been sworn in at that hearing, and that oath would have continued into any subsequent proceedings.
I know that you're challenging the tax board's decision here that the mission, I'm gonna call it the mission, was the owner of the owner of the premises on July 1, 2015, for purposes of qualifying for the religious exception of Section 11. But I just want to review the evidence that the tax board had before them to make that decision. Again, I know that you challenged it, but that's not my question right now. And that would be really the comments made by the two individuals who were representing the mission, and just the document, right? Primarily the purchase and sale agreement. In other words, is that correct?
That is correct. The purchase and sale agreement actually had not been produced by the taxpayer, the rescue mission, in any of the prior proceedings. The assessors actually subpoenaed that document for the reopened hearing.
Okay.
And so it was produced, and there was testimony and there were arguments by the two individuals who were there on behalf of the rescue mission. So I think the purchase and sale agreement is a great place to start the argument here. And I think in particular, I would point out that the Appellate Tax Board really never got into it in its findings of fact here. Under the term,
if I can just ask you, when the Appellate Tax Board decides that the intent of the party was for the deed to actually have really been transferred the year previously, at the end of December 2014, isn't the Appellate Tax Board relying on their interpretation of the P&S agreement? Well, or is there something else that they're relying on?
Well, I don't see how they could be relying on the purchase and sale agreement, because the purchase and sale agreement makes absolutely no reference to any type of relation back as to when title passes. On the contrary, I think the purchase and sale agreement is quite clear. It's set up an escrow type of a closing. There were many conditions to that. In fact, as of the signing of the purchase and sale agreement, the casino had not even acquired the Mill Street property. And in fact, under the purchase and sale agreement, the designation of that property as the so-called new location was only tentative and could have been changed. In addition to that, there were very explicit escrow conditions that would have to take place before a notice of closing was even given. Those included, obviously, obtaining the replacement new property, having that property permitted for use as for the rescue mission. It had to be, the closing date was not set in the purchase and sale agreement. Before the closing could take place, the new property had to not only have been permitted, but a certificate of occupancy had to have been issued. And there was no evidence at all in the purchase and sale agreement, nor was there evidence from the rescue mission representatives that it was the intent that title pass, as of the signing of the P&S, the delivery of the deeds to the escrow agent. And in that regard, I would point out that the deeds were not simultaneously delivered to the escrow agent.
Right. One way.
And in fact, there's a gap there, which would suggest that at some point, under the Appellate Tax Board's analysis, both properties were owned here. And I don't think that that was the case.
The reason why I asked you the question is that if these conclusions are based on the tax board's interpretation of the P&S agreement, then aren't we in the same position as the tax board to review that document and to determine what the quote unquote intent of the parties were? Or are you saying that the tax board could not do that on the basis of the P&S, and neither can we?
Well, I think certainly as it is a document that is before this court can review that document on its own and make its own determination as to what that document says. And I think in doing so, the assessor's argument, of course, is that there is no way that that document could be construed so as to provide for a transfer of title when deeds are handed to an escrow agent. I would also point out, I'm sorry.
I'd like to ask a question about a provision that's not mentioned in any of the briefs, which is provision 9, entitled Acceptance of Deed. And that provision says that each party, I think there's a couple words missing here. I think it meant asking each party. Acceptance of its respective deed shall be deemed to be a full performance and discharge of every agreement and obligation herein contained or expressed, except such as are by the terms hereof to be performed after the delivery of the deed or to survive closing. Why can't that provision be read to mean that the intent of the parties was that the title would be transferred as of delivery of the deed? There were some contingencies that would have to take place after delivery and after closing, but still the intent of the legal transfer was at the time of delivery of the deed.
I think that's actually a very standard merger provision that is in almost every purchase and sale agreement that sets out that after the closing takes place, that is fulfillment of everything in the purchase and sale agreement.
It doesn't say after, it says after delivery of the deed or surviving closing. Right? Delivery of the deed means delivery to the escrow agent, right?
Oh, no, I respectfully disagree with that characterization. The delivery of the deed takes place at the closing under the terms of the purchase and sale agreement. That is when the deed is delivered, not when it's delivered to the escrow agent while there are unfulfilled escrow conditions. And in fact, the ultimate condition here, which I have not previously mentioned, is that the casino at any time could have gotten out of this deal. Mm-hmm. If they didn't get a casino license, they could have gotten out of it. In fact, they could have gotten out of it at any time by paying $650,000. So the casino...
Don't the cases cited by the tax board support the proposition that when deeds are put in escrow pending some contingency, that upon fulfillment of the contingency, the deed is deemed defective from the first delivery into escrow?
I don't believe so. The cases cited by and relied upon by the Appellate Tax Board essentially deal with the death of the grantor and whether or not the delivery to the escrow agent is somehow revoked or become ineffective by that death. And I think furthermore, those particular cases deal with transactions between private parties. Several of those cases deal with family type disputes. They don't deal with the situation that we have here, where the assessors have to look at public records and ascertain what is taxable and what is not. I don't think the death escrow cases have any relationship to a case here. And death being more certain than the escrow conditions too, I point out.
The exemption statute doesn't refer to the record owner, it refers to just ownership, right? So, I mean, these cases to me seem to be relevant in that they go to when is legal title actually transferred? Isn't that the test for purposes of the exemption, not who's the record owner?
I agree that the term record does not appear in both statutes in the same way. I would point out that construing the statutes and the statutory scheme of exemptions and taxation as a whole, that the requirement should be the same. It should be record title.
Why?
Because of the administrative.
No, I don't understand that. I don't understand, to be honest, I don't understand the administrative burden argument. Nobody is saying that the assessors had to determine that the mission was the legal owner for purposes of assessment. For purposes of assessment, the statute says you can send the bill to the record owner. But when the entity who gets the tax bill files for an abatement, certainly then they can provide information that they were the legal owner as of July 1st.
Well, but as of that time, the tax levy and the assessments for the fiscal year have long been set. Mm-hmm. And at that point, it shifts the burden from the taxpayer, which bears a heavy burden of proving exemption, to the assessors halfway through the fiscal year to learn suddenly that, well, maybe this property was exempt because there was a deed recorded in October. I think that is very, as the MAAO and the Mass Municipal Lawyers Association point out in their brief, that is an administrative burden that assessors really can't deal with. Abatements, after the levy has been made, after the tax bills have been set, those abatements come from other taxpayers. If an exemption is processed in a timely manner because the taxpayers filed a Form 3ABC, the assessors are on notice, they've made their investigations, then that property comes out of the tax base.
So if the assessors are so worried about a windfall to Blue Tarp, why wasn't the tax bill sent to Blue Tarp as the record owner?
The first two tax bills, that is the estimated bills, were in fact sent to Blue Tarp as the owner of record. Under General Law, Chapter 60, Section 3, the assessors have the option, or the collector, I should say, has the option of mailing a tax bill to a subsequent purchaser.
But what is the city trying to accomplish here? In the brief, you say that Blue Tarp is going to get a windfall, but you have the option of sending the tax bill to Blue Tarp and not the mission. I mean, they can't pay the tax bill. So I'm just perplexed by the exercise of the option.
Well, in fact, that option is for the benefit of the taxpayers, not just this taxpayer, but taxpayers in general, who acquire the property after the assessment date and issue, and may or may not get the bills from the prior owner. So therefore, the assessors sent it out. And if you look at the bill that was sent out, the two actual bills, they indicate that the assessed owner was Blue Tarp. The failure here was the rescue mission making a deal with Blue Tarp. They opted, the purchase and sale agreement includes the very standard apportionment language that is found in most purchase and sale agreements, just as of the time of closing. The rescue mission in its abatement application said they acquired the property on October 30, 2015. That's when they say they acquired it. And remember, the rescue mission did not, my time is up, I do understand.
Your time is up. That's okay. You can finish your comment. I actually have one more question. I know that the Blue Tarp paid the first 2 quarterly installments, the first one and the second one. The third and fourth, of course, were much larger amounts due based on a reevaluation of the property because of the proposed construction. Now, the valuation aspect is not given the tax board's decisions, not really before us, but why would, are you saying that the mission is responsible for the entire amount of the third and fourth payments, and that their recourse would be to seek reimbursement from Blue Tarp and not an abatement if the valuation is correct? Is that right?
Under the purchase and sale agreement, as negotiated and executed by Blue Tarp and by the rescue mission, the property taxes would be apportioned as of October 30th, 2015. So the estimated bills are only estimated bills, and in doing the apportionment, the taxes for the entire fiscal year would be considered.
Okay.
And Blue Tarp would be responsible for July, August, September, October.
But until, as we sit right now, Blue Tarp has never received a bill for the increased amount.
I don't know. I don't believe there's anything in the record. I know there are mentions in the record by the representatives of the rescue mission that Blue Tarp disappeared, not returning their calls, etc.
Yeah,
Right.
I saw that. Okay, thank you very much. I'm just going to see if the panel has any further questions for you, Attorney Vuono.
Thank you.
No. And okay, Attorney Martin.
Good morning. May it please the court. Bradford Martin, representing the Springfield Rescue Mission. I know that there's probably going to be a lot of questions, but I want to get to a couple of things real quick. When you review the record, the Appellate Tax Board made it clear, I believe in the second hearing, they fully expected this decision that they made by either party was going to be appealed, and that they specifically set out to make sure that the record was going to be as complete as possible and that they could support their decision by substantial evidence. When you go through the record and the decision of the Appellate Tax Board, on no less than 12 occasions did they make findings and rulings with respect to the issue of the religious use, the delivery of the deeds, and the ownership of the property as of the qualification date. And they further—
If I may interrupt you, let's leave the religious purpose aside for the moment, because as I understand the assessor's position is that what really comes down to is who was the owner on January 1 and then again on July 1 of 2015. They represented before the tax board that the mission had not been taxed before. The Bliss Street property, in fact, wasn't taxed at all because they, as far as the assessors were concerned, were the record owners of that property, and they're not taxed in the future. But if you could point me, what is the substantial evidence relied on by the Appellate Tax Board to determine that it was the intent of the parties that the transfer of the deeds on December 30th, 2014 and January 7th, 2015 are the operative date? In other words, what is the substantial evidence that shows that was the intent of the parties, that they were not going to be able to, if the conditions had not been met, for example, be able to void the whole deal?
Well, if you look at the entire record, you have the purchase and sale agreement, which requires both parties to deliver the deeds. The MGM had actually purchased the property by that time.
Was there any testimony as to the intent of the parties? Or is it all based on the Appellate Tax Board's interpretation of the documentary evidence?
Well, there was testimony by the two individuals for the Springfield Rescue Mission, Mr. Batchelder and Mr. Willoughby, that,
And they said that as far as they were concerned, they did not receive the deed until October 30th, 2015.
well, receiving the deed is
Well, they said they weren't owners of the property. Just put that. That's
Wow. yeah.
Well, do you disagree with me there that was what they represented, or am I misreading something?
Well, I think there's an arcane issue of law that maybe non-lawyers may not fully understand. That's clearly the day that the deed was recorded. That was the closing date. But there was plenty of evidence that the parties intended, and as it was borne out, the purchase and sale agreement went through all of the requirements, and it ended up being exactly what the purchase and sale agreement said, that the deeds were delivered, they were held pending certain activity, that activity was completed, those conditions were met, and the deeds were then recorded. Nothing really changed. There was no alterations, no deviations from what was done in December when the original deeds were delivered to the escrow agent. And
Do you read the word delivery in the PNS to refer to delivery to the escrow agent?
yes,
Okay.
I do. And excuse me, Judge Vuono, you indicated earlier that you didn't think, and I don't mean to get off base here, but that the valuation isn't before the court today?
Well, what's your position?
Well, I mean, the decision that's being appealed from says the principal issues raised at this appeal are whether the assessors overvalued the subject property and whether they properly imposed a tax on the mission for the fiscal year in issue. And I would just say that they spent considerable time talking about that in the decision. And that they said the valuation by the assessors was fundamentally flawed. As we stand here today, the assessors have no evidence and could produce no credible evidence, according to the Appellate Tax Board, that the improvements to the property were actually made on June 30th at the end of the look back period. And so even if, and I'm not conceding anything, but even if you were to say that the delivery and title and anything else, the tax bills that were sent are flawed to the point where at this stage, they can't be supported by any evidence at all. And I think that's a very problematic issue for the city. When you read it in the decision, and they spent 5 pages talking about it, they said you just simply can't take estimated bills and expenses and future prospective costs and say that those were in place for the purposes of valuation at the end of a look back period, which was June 30th. In fact, they said the testimony and the evidence was to the contrary, that even the city's own documents supported the fact that the work hadn't been done. And therefore, to place the value that they placed on it, I think was ill-founded and, to quote the board, fundamentally flawed. And that puts the city in a real tough position because I don't think they can justify legally what the valuation was when they sent the bills for the third and the fourth quarter.
But the board's ultimate finding had to do with the fact that the mission is exempt.
Well, I think they passed over the valuation issue because they made the decision based on their hearing of the evidence, which they said was credible, uncontroverted, unrebutted. They used those terms many times in their decision, that the that the mission was in fact the owner for the clause 11th qualification time of July 1st, 2015.
So how are we supposed to evaluate the evaluation issue? In other words, the board is relying on primarily the documentary evidence that the purchase and sale agreement to as substantial evidence for their conclusion that the deed was delivered once all the in December and in January, once it was delivered to the escrow agent, that it was that then became valid once the subsequent conditions were met. But it doesn't say anything about what the proper valuation would be.
It doesn't, because that was up to the city to produce that evidence. I mean, the original application for abatement dealt with the fact that this was an overvalued property, and it flowed from there. And I admit it's gone in a different couple of directions, but the initial application was the fact that this property was not properly assessed in terms of valuation by the city.
And who has the burden of approving the improper valuation?
Well, when you look at what the appellate tax board said, they had no evidence, basically, or no credible evidence of what the valuation was. Therefore, they said they put the mission in an untenable situation of trying to prove what the valuation should be when the city couldn't produce what they based the valuation on. Because what they based it on, according to the appellate tax board, was fundamentally flawed. That you cannot assess a valuation for something that doesn't exist at the time.
So am I hearing you say that it is the burden on the taxpayer, that it is the mission's burden, but in this case, they were somehow excused from it given the difficulty of obtaining discovery and things of that nature?
Well, normally,
and because they really weren't represented by counsel at the time?
Well, normally in a traditional appellate tax board appeal hearing, you bring in valuation, you would bring in experts.
When you say you, are you referring to the taxpayer?
Yes, Your Honor. Yes, the mission or the party filing the.
And they didn't do that in this case.
They didn't do that in this case, but the appellate tax board said it almost the valuation is really void ab initio. It could not be sustained because it was flawed. I mean, they didn't have any evidence, and to suggest that the city should get away with assessing property on specious valuations, I think is as unfair as the city is claiming, because maybe Blue Tarp might get a little bit of a benefit out of this.
Well, they're claiming that's more than a little bit of a benefit. It's 3 months worth of real estate taxes, according to the assessors.
According to the assessors, that's correct. But as opposed to the burden on the mission.
Well, the appellate tax board expressed some concern or distress, shall we say, about the entire situation, given what the mission had been led to believe in the beginning, that if they were forced to move from their Cliff Street property, that they would not incur any expenses. Where do you see Blue Tarp's role in this? Because it seems to me that, was it you that were representing the mission at the time, and that Blue Tarp, I know, supplied the attorney for the mission during the course of negotiating the purchase and sale agreement? I don't know if that was you or somebody else. I don't want to put you on the spot there.
One and the same, yeah.
Okay.
It was me.
Well, why isn't Blue Tarp bearing some responsibility here? In other words, part of the purchase and sale agreement could have easily have been to be sure that the mission was the record owner by July 1. And if that had been the case, the problem would have gone away.
Well, I mean, I suppose that could have said at the time, remember the purchase and sale agreement was signed in May of that year. It was signed before the property was identified in terms of where the mission was going to go. So I'm not so sure at the time of the purchase and sale, we could have known when the closing was going to take place. Mm-hmm. And nobody knew how much work was going to have to be done. The acquisition of the Orr Cadillac building was a significant undertaking. Nobody knew at the time that that's what it was going to be. I don't know that you can place the burden on the mission at that time to know what was going to happen down the road before even the property was identified.
True, but at a certain point and pretty early, well, by October 30, 2015, Plutarch, when the final recording was made, was certainly aware of the tax situation because they had already paid the first two installments, the first and the second.
Correct.
I guess what you could say what they didn't know was that there was going to be an increase in the value.
Nobody anticipated that. And the problem from as the lawyer for the mission, my job was to make sure that they received clear title. And we had to do whatever we needed to do to make sure there was no lien on the property, which would have been if taxes remained unpaid. There really wasn't room under the agreement to get into a fight with Plutarch about the taxes. But you know, this was not the usual real estate deal, and I think that the appellate tax board took that into account as well. That this was I think they saw it for what it was, and that was the mission exchanging one tax-exempt property for another.
If I may ask one more question, Judge.
Sure, please go ahead.
How do you respond to the argument that Plutarch is getting a windfall here because the Bliss Street property was exempted, right? So yes. How do you respond to that?
I think that may be the opposite of the burden placed on the rescue mission, which had a long 120-year history of being exempt. They have a burden. Whatever benefit flowed to Plutarch, frankly, was clearly made up by the fact that the city was the major beneficiary of the casino coming to Springfield, received millions and millions and millions of dollars in terms of revenue, taxes.
But none of that is before us or has anything to do with this particular case, does it?
No.
Okay.
But I mean, it was.
Well, was the city privy to the negotiations between Plutarch and the mission?
They knew all about it because Plutarch, when they acquired the property, made sure that they had proper zoning approval. And that all occurred in December of 2014. They received a zoning opinion from the city of Springfield for the purposes of relocating the mission to the Orr Cadillac building because the zoning was different. And all of that was clearly done with the understanding that Plutarch was going to acquire this property for purposes of moving the mission to it.
And there was also publicity with respect to what was going on in terms
It
of
was,
things.
this was the worst kept secret in Western Massachusetts about what was going on. And,
But does that involve necessarily, to Justice Shin's question, does that, when you talk about the city of Springfield being aware, are you saying that also includes the assessor's office and the collector of taxes? That they
Yes.
Okay.
yes.
I didn't mean to interrupt. Justice Shin, did you have any more follow-up questions?
No.
All right, well, thank you both very much. We'll take the case under advisement and seeing no more questions. Thank you both for answering all of our questions. We appreciate it. We had many of them. We'll get an answer to you as soon as we can. Meanwhile, we hope that you and your family stay safe and healthy, and take good care of yourselves during this till today.
We are live.
All right, it's almost noon, so I'll say good afternoon to you both, and thank you for your patience and for participating in oral argument today on this remote platform. Joining me today on the panel is Justice Jeffrey Kinder and Justice Suk-Young Shin, and my name is Ariane Vuono. Just a quick reminder that the rules of appellate procedure apply on this platform as if we were in the courtroom, and you have each 15 minutes to make your argument, and there is no rebuttal. I am hearing a bit of an echo. I don't know if anybody else can hear that as well. Sometimes that happens if someone is still in the waiting room or has another device on following the arguments today, as well as being on. And if either of you have that.
I don't think so, Your Honor.
Okay, no, neither one of you?
No, Your Honor.
Well, let's just go ahead and start and see how it goes. Hopefully when the two of you speak, we won't have that echo and we'll be able to understand your arguments, all right? So I'll call the case 2020-0120, Anthony Michael CHAYANNE, is that how you pronounce the name, versus Jennifer Lee CHAYANNE, or perhaps mispronouncing the name. You can tell us the proper pronunciation. And if I'm correct, Attorney Dargy, you represent the appellant, correct?
Yes, thank you, Your Honor. Good morning. May it please the court. My name is Ann Dargy, and I'm appearing on behalf of the plaintiff appellant, Mr. Anthony CHAYANNE. Understanding that the courts have reviewed the briefs, I would turn to what is essentially the primary two issues in this matter that lead to the need for a review of a third issue. The first issue is for the court, and it requires significant review, is the issue that the court entered shared parenting schedule that is not supported by either the findings or the evidence presented, and further that the guardian ad litem that was involved in this matter also provided significant recommendations relative to a parenting schedule, and the court also declined to enter the recommendations from the guardian ad litem, failed to indicate why. I'll start with the issue relative to the court's findings and the lack of support for the parenting plan that was entered. Court's premise really premised the judgment, the equal parenting time judgment, focused on two propositions. First, that the wife was addressing her alcoholism, and during the litigation that she was engaged in AA and that she was engaged in individual therapy, and I believe also with life coach. And secondarily, that the children enjoyed the time with mom, with wife, and that they would benefit from more. So to address the concern relative to the court's premise that the wife was addressing her alcoholism, the fundamental problem with that as a basis for entering an equal parenting schedule is that even while the court, during the litigation, even while the mother was engaging in this treatment, she continued to behave in a way that was concerning both to the guardian ad litem and to the court. The court gives a number of examples in the findings as to the behavior by mother that was not only concerning, but contrary to the children's best interest. I would focus and certainly turn court to a couple of specific examples which are outlined in the brief, but they're revisiting. One of them being that this is a somewhat unique issue, that the wife refused effectively to leave the home. She re-entered the home after there had already been an order relative to a parenting schedule. She re-entered the former marital home, refused to leave, and made some suggestion to husband, who had sole custody of the children at that point, that the parties would share the home. Court had a number of concerns, as did the guardian ad litem, relative to that behavior. But most importantly was that in doing so, the mother essentially forced the children out of their home, forced them into a home in a different town where father had been residing, which was in West Springfield, compared to Agawam, where the former marital home was. The father was in West.
Can I interrupt with a question, please? I don't hear you saying that the mother's efforts at recovery from her alcohol problem was an unfair consideration for the judge, or are you saying that?
I am saying that, Your Honor. I am certainly arguing that as a consideration, whether it was, although I think the judge, and it's clear in her findings, really did focus a majority of her reasoning and her basis for expanding into a shared parenting schedule was on the fact that the mother that wife was allegedly working toward addressing her alcoholism. I think the fundamental problem with that as a basis is that even while the mother was engaging in these therapies, she continued to behave in a way that was exceedingly contrary to the children's best interest. And the judge is bound by that as an inquiry.
I understand that there may be other reasons that she exhibited even beyond her recovery, in addition to her recovery from alcoholism. I guess my question is, what was inappropriate about the judge considering the mother's recovery from alcoholism?
That in and of itself, Judge, I agree, is not an inappropriate inquiry. To consider that the recovery is happening isn't inappropriate. For that to be is essentially one of two foundational reasons for entering an equal parenting schedule. I think that's the piece of this that's inappropriate. I think that there was a number of examples and a number of concerns that were voiced both by the guardian ad litem and the court relative to the mother's behavior. And this case is unique in that the behavior that really gave rise to the need for sole legal custody, for example, which was part of this judgment to husband, happened during the litigation. And it was happening as we were litigating the matter during motion practice, during contempt. It was wrapped up into contempt complaints. There were a number of continued issues and continued behaviors by the mother that made clear she really did not have an ability to put the children's needs ahead of her own. And a concern at that point now becomes that for the court to expand a parenting schedule where the parties had entered into a temporary agreement that the children would have it was 2 dinner visits a week and an alternating weekend, Friday to Monday. The court to expand into what is effectively a shared parenting schedule on just the basis that she was addressing her alcoholism does not take into consideration, fails to take into consideration a number of extremely important factors, one of which that regardless of any broad discretion that may be argued by the opposition, the court is bound by a best interest inquiry for the children. There are a number of findings.
On that point, didn't the judge specifically find that the children would benefit from fewer transitions from mother to father and father to mother?
I think that, the court made that statement, Your Honor, but that statement in and of itself doesn't support this parenting schedule. I think in the first instance, and in fact, the guardian ad litem recommendations, and this leads into that argument to some degree, the guardian ad litem interviewed the children, and there is nothing in the guardian ad litem report that suggests that the children would benefit from additional time. I don't believe that the judge provided any specific findings indicating that the children, particularly I think much of the discussion was around the party's daughter, that there would be any benefit to the children being exposed to a parent, particularly who doesn't have an ability to support the children's best interest, not only to not support their interests.
Didn't the daughter say that she wanted to spend more time with the mother?
The court found that. There isn't any evidence in the record to support that finding. And in fact, a review of the guardian ad litem reports, which are in the appendix, there isn't, the child doesn't say that. And I think the child alludes to that makes some allusions to it, but part of what the guardian ad litem investigated, and in part what she testified to, was that there was some really significant concern that the mother was coaching the children, influencing the children to say certain things, particularly where the child actually said to the guardian ad litem, "I wish mom would stop talking to me about
Right.
the parenting."
So the guardian ad litem said she couldn't say for sure whether the mother was influencing the daughter, but why wasn't that a factual issue for the judge to resolve?
I think that the judge, it very well may have been, the judge didn't resolve it. I think that's part of the issue, or at least the overarching concern in this case, is that the judge made a number of findings that are now not consistent with her judgment. She didn't resolve that issue. She made the only recommendation and the only findings, she certainly credited findings of the guardian ad litem, didn't expressly ever indicate why she wouldn't have followed the guardian ad litem's recommendations, recommendations relative to parenting time. I believe, in fact, the only recommendation by the guardian ad litem that the court even notes that she isn't following is the recommendation that the parties not be present at the children's extracurricular activities together. The judge acknowledges that finding and indicates that she's declining to follow it. The lower court in this case didn't do that on any of these other findings. And really the concern comes that the court, without giving any specific reasons or resolving these issues around the best interest of the children, granted mother an exceedingly expansive parenting schedule. And although in the opposition, there's some indication that the guardian ad litem drew back on mom's time, that's effectively not true. The mom had 2 dinner visits, and now she's granted 2 weekdays, number one, and week overnights. So she now has Monday and Tuesday overnight. And the concern there is that is also a time that the father doesn't have the children. That's another piece that the judge did not address. There was, not only does mom now have Monday through Wednesday, for example, but that, when looked at on a global scale, on a calendar scale, results in father, when it's mom's weekend, doesn't see the children for a period of 5 days, which is significantly more time than he was away from them throughout the litigation. The judge made no findings that was appropriate for the children. She made no finding that it would be in the children's best interest to be further away or to have such significant time away from the parent who the court really does deem the more stable parent. The more stable parent, the parent who is best able to address the children's needs.
Well,
so
it seems like the findings, well, the judge found that that both parents behaved poorly at times. And despite that, though, the children love both parents, have good relationships with both, enjoy their time with both. I mean, is that really in dispute here? As far as the children's relationship with the parents?
My client would dispute the fact that the children's relationship is the same. From my client's perspective, he has and continues to hold that the children are, he has more structure in his household and that he has a better ability to manage the children's day-to-day needs, and that mother very regularly, and there's evidence throughout this case that the mother very regularly would put her own, not just need to win, certainly her need to win the litigation, and which the judge also found and had concerns about, but that she has this control, I think for lack of a better word, a need to control the children in a way that the father simply doesn't. And so I think from his perspective, he would argue that his relationship with the children is healthier.
Why aren't those concerns more relevant to the issue of legal custody as opposed to the parenting plan?
And the fundamental reason for that, Your Honor, is because when you have continued exposure, the concern from my client's perspective, and I think from the guardian ad litem perspective in this case, is that continued exposure to mom, when she doesn't have an ability to promote the children's interests and put the children's interests ahead of her own, that continued exposure to such a parent is not in the children's best interest. There was never a finding made.
The judge effectively granted one additional overnight to the mother, right? In comparison to what the guardian ad litem recommended.
That's correct. Yes, but the guardian ad litem schedule was also with one additional overnight alternated, So the key point to that is the time away from dad, the time that dad doesn't have an opportunity to, for lack of a better phrase, put eyes on the children. That he's the schedule, and we refer to it in the litigation arena as a 3-3-5 schedule, where children are with each parent 3 days, and that 5 days, a 5-day stretch attaches to the parent's alternating weekend, which was not what the guardian ad litem contemplated. The guardian ad litem didn't contemplate that such an excessive period of time away from father, where father had been the primary parent throughout the litigation, which was long. It wasn't by any means a short time frame, and that he was the more stable and the more available of the parents as far as emotionally supportive. And so I think that when there certainly is a distinction between a legal custody inquiry and a physical custody inquiry, but I think that the concern at that point is that how much exposure and how much time are these children spending with a parent who doesn't have an ability to co-parent, which the court specifically found, and it seems to, and the court's, I believe, exact word was, have a campaign against father with respect to his parenting, an inability to recognize that he's a parent, essentially. And so I think that the ongoing exposure to a parent who behaves that way, and such significant exposure and significant time to a parent like that, is not in the children's best interest, nor did the judge make that finding. So I would turn just briefly to the second issue with respect to the those findings and those recommendations made by the guardian ad litem, that the court declined to enter that order and enter the schedule that was proposed by the guardian ad litem after very, very significant and lengthy investigation. And that's, again, probably my reading, and I would posit to this court that when the Ventris matter is read in conjunction with other cases, such as the both Prenovo cases, that the lower court is truly required to enter specific findings relative to the guardian ad litem recommendations, whether or not they're followed, but certainly if they're not followed, that specific findings should be entered on that basis. And in conclusion, simply would also note to this court that time should not be a factor, that realizing that this parenting schedule has been in place for some time, that the issues that gave rise to a need for sole legal custody and the mother's behavior continue to this day. So I hope that the court would look at this not just in a vacuum, but that recognizing that these children still require relief. Thank you.
Thank you very much. Attorney Williams?
Good afternoon, Your Honors. May it please the court, Attorney Heather Jill Williams. I represent the mother, Jennifer CIOLLARO, in the pending appeal. First, I would like to address the last comment made by my sister. There is active litigation involving this family with continued cross allegations in the lower court, which should not in any way be a factor in how your court views a review of the record and views what occurred at the time of the divorce hearing. That being said, I do believe that what this really is, even though there's not a lot of attention paid in the brief to the child support issue, this is a child support issue. The guidelines tell us, and the task force refers to the principles of the guidelines, that we should look to find a parenting plan that is in the best interest of the children first, and then calculate child support. My concern, I share with my client, that this is really, the concern is dad is looking to get that day back because he wants the child support to be recalculated. I recognize that wasn't a focus of the brief because really we don't get there unless the schedule changes, but that's really the driving force. The history in this family is a little bit tragic, but very much outlined by the judge's findings. They was a very short-term marriage. They had 2 children. Prior to September of 2017, it is undisputed, and it was found by the judge that mom was the primary caretaker of these 2 young children. Unfortunately, she did struggle with alcoholism. She did have a mental health incident. The court then appropriately gave dad temporary custody. That was very appropriate. However, mom then crawled her way back from the depths of despair and proved time and time again that she could again be an excellent parent for these 2 small children. And the children told anyone that would listen, that they loved their mom and they loved spending time with their mom and they wanted to spend more time with their mom. And I disagree with my sister's characterization. I cited exactly in my brief the place in the record where this child, the daughter, when the father brought the daughter to be interviewed by the guardian ad litem, mother was nowhere around, and she clearly articulated that she wants to spend more time with her mother. And that then transitions into what's happening here. The parents do not get along. It is clear there is acrimony. However, what is equally clear is, in spite of the parents' acrimony, the children were doing well. They weren't reporting, I see mom and dad fight. I see all of these things that makes me uncomfortable. The parents sheltered their children from their own disputes. That was a concern to the guardian ad litem, and she indicated that even though that was happening now, that there was a potential in the future that these disputes could inflame, and wanted to protect the children from transitions. The judge took that recommendation and abided by it. She made the transitions. Unfortunately, we're dealing with COVID, and now we do have some household transitions, but the intention of the order was transitions occur at school. So that limits the contact between mom and dad. That limits the opportunity for any exposure to conflict. I would agree with Your Honor when you indicated that this is really a legal custody issue, that mom's poor behavior resulted in her losing shared legal custody. My client did file an appeal on that issue. She didn't properly preserve her rights, and that did not get pursued. However, the arguments made by my sister, both in her brief and today, are legal custody issues. Mom doesn't behave well, therefore she shouldn't be making decisions. I would also submit that the lower court found both parties did not behave well. And in specific, although we're relying on the Hernandez-Betancourt case, that case speaks to when a parent is being found in contempt, when they're not complying with court orders relative to parenting time. And in this case, if we look at the record at the lower court level, it was dad who was found in contempt before the judgment for interfering with mom's time. It was dad that wasn't following the parenting orders. So if we're really going to rely on that precedent, then dad should have lost time with the children and custody should have been given to mom. And that's not what the court did. The court looked at the totality of the circumstances. They looked at the history of the parenting of these children, and they made the court made the best order that could be made in the circumstances, supported finding by finding by finding as to why that made sense. The court also talks about the positive attributes that mom has as a parent and goes through those in the findings. The guardian ad litem speaks about that. It is absolutely not true that there was no finding that mother was a good parent. She was a bad co-parent. She was a bad communicator with dad. That is undisputed. That is why she does not have shared legal custody. But as it related to the day-to-day care of the children when mother had them in her care, mother was an excellent child care provider. And the children were very bonded to her, and the children remained very bonded to her, and it was undisputed that they would benefit from more time. The guardian ad litem's proposed schedule in her report was a reduction of time for mom. It was not an increase of time. The court took the recommendation to increase mom's time and appropriately increased it. The court took the recommendation to limit transitions and appropriately made orders that would allow for limiting of transitions.
Where
I also would like to
counsel, where is the recommendation that mother's time be increased?
It's in the guardian ad litem report. Let me just give you the exact citation. I have the record appendix, volume 3, pages 83 to 84, that the children should have meaningful and significant relationships with both parents. And I believe I cited it in my brief, if you just give me a moment.
Well, in your brief, you say that the guardian ad litem recommended expanding mother's time from what was in the temporary order, but there is no citation.
Yes.
Do you have a citation?
Hold on. Just keep it. One moment, please. I had it flagged. I apologize. Just in the recommendation section.
It's in the report or the testimony?
It was in the report, I believe.
Okay.
And as well as in cross-examination, there was some
Okay.
reference.
I don't want to waste your time. So you can go ahead.
Thank you, Your Honor. So the issue then becomes, when looking at whether what mother's motivation was and what her behavior was, in the brief submitted by father, they refer to this issue about mother was bringing lunches to school in spite of not that being told that was disruptive. And there's also a finding by the judge about mother bringing lunches to the children's school during dad's so-called parenting time. However, what the record is that mother brought lunches to the school and it was disruptive and it stopped. There's no record that says, even after mother was told to stop doing this, she persisted. It was an incident, it was occurring, she stopped. I could not find anywhere in the record that would support that statement that mother was behaving in a way after being told not to. And that was a concern I had with an unsupported statement in the appellant's brief that indicated that mom was behaving poorly even after being told not to. Another concern that we have is that we're dealing with two small children. It was uncontroverted that they were bonded with both parents. To dad's credit, he stepped up when mom had this incident. But that doesn't mean that now forever and always, mom is precluded from having a shared schedule with the children. There was no evidence that suggested that mom's time with the children was detrimental. There was no evidence that suggested that mom having 3, 4, or 5 days with the children would be a harm to dad. I recognize there's this argument that the court didn't consider that in expanding mom's time, there was a decrease in dad's time. But I would argue that the court is very astute and is well aware that you can't make up time. Time can only be allocated certain ways. And it is plain as day that when one parent gets additional time, that time comes from the other parent's time. The court was well aware that that was occurring. And I don't think there's a necessity to make a specific finding by any judge that reads, well, I'm giving mom more time and we don't think it's bad that dad has less time. It's a nature of the beast that when a schedule is changed, one parent will lose time, one parent will gain time. But really, it's not about one parent losing or one parent gaining. It's about crafting a schedule that allows the children to have a meaningful relationship with both parents in a way that supports their needs. And I believe that Judge Weiner did an excellent job, not only in a very difficult case, crafting a schedule that makes sense. The schedule that was ordered was not one requested by either party in their proposed findings. It wasn't what anybody really wanted, but after a review of all of the evidence, the judge took into consideration what is in the best interest of these children, not what does dad want for time and what does mom want for time. What do the children need? What can the court do to best suit the children's best interest and their needs? And that was supported time and time again, finding after finding after finding, where the basis was in the record, where the basis was in the testimony, what the GAL said, what the collateral said. And I thought the lower court did an exceptional job with expansive findings to support the position that the court ultimately concluded that a shared parenting schedule, which is different than the arguments on the legal custody that are being proffered to say that the court made an error. The other issue that we had in terms of refuting these statements were that this concept that mom somehow didn't treat her alcoholism that we started to hear again today. It was undisputed that mother took every single step to maintain sobriety. Undisputed, she followed every recommendation, both with her sobriety treatment and any mental health treatment relating to the attempt at suicide. So to suggest that because mother was behaving in a way that is being interpreted as contrary to the children's best interest, where mother testified that the reason she was being such a zealous advocate and trying to point out all of these issues with the parenting schedule is because up until her incident, she was the primary caregiver. And she recognized that she had a problem. She made a grave mistake. And she had concerns about how the children were being parented when they were switched from her primary care to dad's primary care. And a lot of her concerns fell on deaf ears. And I recognize that the record is, when you look at the totality, some of her concerns about things happening in dad's house, they're minimal compared to a mother that struggled with alcoholism and had a suicide attempt. And we can't try to make a perfect parent out of both parents. We can't say, okay, yes, you're better now. You've dealt with that. So now all the little small things that you have an issue with dad's house, we're going to take away custody from him because of that. And she struggled with understanding that because dad wasn't parenting the way she parented, and she was pointing out all the things along the way that were different, that didn't toll the bell. That didn't make a change that suddenly custody was going to switch solely back to her. And perhaps she was misguided in her approach, where she kept attempting to point out all the things that dad was doing different than how she parented when she was a primary parent. And at the end of the day, the judge considered that, and she lost. She lost legal custody of her children because she was trying to prove that dad was not doing things the best way. And that was her punishment, but that should not be the children's punishment. The children benefit clearly from a relationship with both parents, and the judge made a schedule that made sense to allow that to continue. And I could not find, again today in preparation for the brief and over the weekend, a citation where mom had behaved inappropriately while the children were in her care, where mom had done something inappropriate during her parenting time that would say we should not expand her parenting schedule. Mom behaved inappropriately outside of the parenting time. That was found by the judge. Mom tried to work with the professionals in a way that the judge found was subverting dad's role as a father. But in terms of her interaction with the children, I did not see any citation by the GAL, by the findings of the court, by the record presented, that mom was inappropriately parenting during her time. And really the argument before your court, your honors, is a time issue, which gets me back to the initial statement that there are serious concerns that this time issue is being driven by a child support issue and not really a custody issue. So I think I would rest on my brief, and I'm certain the court has already taken the time to read it, and would not like to be redundant with any further arguments. So if there aren't any questions, I would rest.
Okay, thank you very much. I'll check with the panel, and I don't see the panel having any additional questions. I want to thank you both very much for your arguments. We appreciate them. We'll take the case under advisement and get an answer back to you as soon as we can. Meanwhile, on behalf of the panel, we hope that you and your families remain safe and healthy. All right, Attorney Healy, I didn't hear you. Can you hear us?
I can now. Thank you, Your Honor.
Okay, great. Well, good afternoon, and to all of you. Let me introduce the panel before you. My name is Ariane Vuono. I'm joined by Justice Jeffrey Kinder and Justice Suk-Young Shin. Just a brief reminder that each side has 15 minutes, and I understand that the attorneys for the department and the child are splitting their time. We have that already calculated. There is no rebuttal, as you know. Upon occasion, today we've had a couple of glitches and technologically. Let's hope we don't have any more now. There is no rebuttal, as you know. Upon occasion, today we've had a couple of glitches and technologically. Let's hope we don't have any more now. I guess I shouldn't have spoken so soon. Upon occasion, today we've had a couple of glitches and do one of you have, there we go. Perhaps one of you had one of your other devices open so that you could be following what was going on this morning. That's what sometimes happens. I see you now are all on mute, but can you can still hear me? You can shake your heads. Attorney Levin, can you hear me? I think that he may be frozen. Okay, there we go. No. Shake your heads.
I hear you, but
Attorney Levin, can you hear me? I think that he may be frozen.
I am hearing a strong
Okay,
echo.
there we go. No. Shake your heads.
I hear you, but
Attorney Levin, can you hear me? Well, not only is there an echo, but there's.
And we are back on the record.
All right. So you've already heard my preamble, so let's just go ahead and start. So Attorney Healy, you represent the father. Of course, as you know, this record is impounded.
Thank you, Your Honor. Your Honor, may it please the court, my name is Julia Healy, and I represent the appellant father in this matter. The real issue in this case, Your Honor, is poverty. DCF had a legal obligation to strive to keep my client's homeless family together, and they did not. The lower court erred in not making an even-handed assessment of the evidence, which assessment would have shown that my client did not have issues and did not take action, placing his child at risk of serious peril from abuse or neglect. For example, the lower court erred in finding that my client had substance abuse, mental health issues, a dangerous criminal history, and domestic violence in the relationship. The evidence simply did not show any of these issues existed. With respect to a substance abuse disorder, Your Honor, the lower court made 8 findings of facts regarding a substance abuse disorder, but only one of them actually spoke to such a disorder, which was in a 51A made before the child was born, which was unsupported and under Carita cannot be used for the truth of the matter, stated the reporter suspects substance abuse by both parents. The other 7 findings of fact speak to the service plan requiring services for substance abuse, has a clearly erroneous finding that the parents argued about my client drinking daily, which there is no evidence to support. And then there were 3 findings of fact. One is which my client did tell his social worker he does occasionally use marijuana, and that at one point the social worker, the caseworker, saw that he was calm and had a flat affect and smelled of marijuana. These findings of facts do not support the court's legal conclusion that my client had a substance abuse disorder and that it would pertain into the immediate future. The court ignored the positive evidence such that there was no indicia in the over 100 police reports that are in the record. There's no indicia of substance abuse in any of those or on my client's board of probation record, which contains absolutely no convictions. The court itself admitted that the police often, that most of these 100 police reports were the police patrolling areas known to be occupied by the homeless, and that in most of those police reports, my client was cooperative and wasn't doing anything wrong.
Didn't a lot of those police reports, however, involve responses to arguments between the father and the mother?
Your Honor, to be specific, with those police reports, 20% of them, my client was simply there. In 20% of them, my client was asked to move along, and he did. In 10% of them, he simply listed as other on the top of the report, but not named in the report or anything in the report. 6 of them were the police checking on him at checking a shelter, and he was always well behaved. In 5 of them, he was asleep, awoken by the police and asked to move. In 2 of them, he was trying to charge a cell phone, and in 1 of them, he was the victim of an attack. What Your Honor might be referring is there are some reports where my clients were arguing. No, never physical, they were verbally arguing. But again, what the lower court ignored is my client is homeless. That was clear throughout this case. He had nowhere to go. He did not like staying in a shelter because he said that there were pedophiles there and he preferred to sleep on the street rather than go to a shelter, which were his only 2 options. In some of the reports, the police were called because the parents were arguing. I believe at one point, mother was late coming out of a shelter, and so my client yelled out to her, "Come on, hurry up, move along." There definitely were arguments, but there was nothing physical and nothing that showed a mental health or a substance abuse issue or a domestic violence situation. The basic problem in this case, Your Honors, is DCF ignored its obligation under Mass General Law and under its own promulgation of 110 CMR to serve homeless families. DCF always has to provide services, we all know that. But with respect to homeless families, 110 CMR gives them an added obligation to serve them even more. They created their own mandate, which is to serve homeless families to ensure that they stay together, which includes providing access to facilities, providing them a place to sleep and meals, and allowing them a place to feed and bathe and care for their children, and to provide comprehensive referral services. Had DCF done this, let me back up, Your Honors. The problem in this case is we don't know if my client is a fit parent or not because he never got the opportunity to parent. The child was removed at the hospital at birth due to mother's substance abuse. My client never did anything. There was never a 51A against my client. 2 51As, 1 unsupported, 1 supported, both against mother. But they removed the child. Had they followed Mass General Law and their own regulations to service my client and try to keep his family together, we would have evidence of whether my client was fit. And if he were not fit, had they provided these services, he could have become fit. So the fitness would not have continued and there would have been no need to terminate his rights. The problem with this case is DCF very quickly started labeling my client. He has a substance abuse disorder. He has serious mental health issues. He's violent, which again, none of this is in the record. The lower court then adopted these labels, literally in her findings, they adopted these labels without having any evidence to support them. And then said, well, because of these labels, father is unfit. The lower court, as I said in my introduction, erred by not actually looking at the evidence and thinking, wait, these labels don't pertain. There is no evidence here for any of these. Turning to mental health, the court made 2 findings of facts regarding mental health, only 2. One of them is that the only 51B was supported in part because of a mental health issue. What the 51B said is in the very, I think, second to last page of it, both parties have mental health issues. Nothing in the 51B or anywhere else in the record to support that. DCF just put that in the conclusion. The judge made a finding of that, and the judge made a finding that the first service plan included treatment for any untreated mental health issues. Obviously, that is not evidence that my client had a mental health issue. DCF actually took the mental health treatment off of the first service plan, kept it on for mother, took it off for my client, and the second and third service plans did not have that. So again, every finding, the substance abuse, the domestic violence, the criminal history, there is no evidence. My client was constantly watched by the police. The lower court admitted that, has 4 entries on his record. 2 of them, I believe one of them was dismissed, one of them was pretrial probation, and 2 of them were community service. There is no criminal history there. There's simply the police. Believe me, if he were doing anything, the police would have found it, given the amount of eyes of the police that were on my client. Turning to the services, if I may, Your Honors, the lower court erred in finding that my client's inability to routinely comply with the service plan was indicative of his unfitness. First of all, the service plan tasks did not relate to a known parenting deficiency. And under the case law, inability to follow a service plan is not relevant to fitness if the services are not tied to an identified parenting trait. In addition, DCF failed to provide my client these services. And as I quickly talked about, Mass General Law and 110 CMR mandates DCF not simply to give a client a service plan, especially a homeless client a service plan. They actually have to provide, to supply, to help somebody get these services. In the first service plan, DCF gave no contact information for providers whatsoever. This is a gentleman who doesn't have a phone, who doesn't have a home, who doesn't have money for a bus. He was told to get treatment. That, again, DCF is not allowed to do that, and the court erred in relying on his inability to use a service plan. The second service plan added more tasks, but gave 2 phone numbers and 1 address. Again, my client did not reliably have a phone. He did have a government phone at times, which he was unable to keep charged. And there are actually police reports where the police not only moved him along and kept him from charging a phone, but then called maintenance or an electrician to undo the charger in that area so he couldn't use it again. And the third service plan gave absolutely no more information as well. Turning to visits, Your Honor, the court erred in finding that my client's missed visits were indicative of his inability to parent. Court made 10 findings of facts about visits, that sometimes he did not appear, sometimes he did cancel. However, my client was clear with DCF from the beginning that he did not have a reliable cell phone. And what did DCF do? They changed it from him having to confirm just the day of the visit to him having to confirm the day prior and the day of. They made it harder for him knowing he didn't have a phone. That is a complete violation of 110 CMR and Mass General laws. They also, there was no finding that the visits went anything but well. The court did make findings of facts regarding the 2 visits that did occur. And in those visits, DCF had no concerns. He held the baby, he introduced himself, he did everything right. And under adoption of Imelda, missed visits cannot be found to be indicative of bad parenting if they were not grievous and did not place the child at hazard. And there's no evidence that they placed the child at hazard. In fact, there's evidence that he tried to get to visits, and when he went to visits, it went well, and that DCF knew why he wasn't able to go to the visits. He did not have a phone, he did not have transportation. And there's actually one visit in particular where he said to, excuse me, Your Honors, he said to DCF, I will not have a phone the day you've scheduled this visit, I will have a phone the day before. May I call the day before? Only they said no. He called the day before and said, as I told you, I will not have a phone tomorrow, but I'm coming. And they said, you have to call tomorrow or we're going to cancel the visit. And they did. They canceled the visit. The judge erred by ignoring all of the evidence as to why my client was unable to not make those visits. He also called twice to confirm when he did have the phone sometimes. This is not a gentleman who abandoned the proceedings, who did not want to be part of this. At one point, Your Honors, he went to DCF unannounced because he didn't know when he could go and said, I'm trying to get Mass Health. In fact, one of his arrests was him going to a clinic that had a no trespass against him, saying, I don't know where else to go. I'm trying to get health insurance. I want to get my child back. I'm trying to get my life back on track. And they kicked him out. Your Honors, there was one time where he went to DCF and said, I am trying to get Mass Health. Will you help me? The social worker said, I won't print out the application now. Come back another day and I'll print it out. He missed that visit, but came back another time and said, okay, now I can be here. Can you please give me the application? Again, DCF said no and asked him to come back again. This case is DCF setting up my client to fail, not only ignoring their legal obligation to help him, but setting up visits so that he has to call twice, setting it up so that they won't give him a Mass Health application when he appears, setting it up so that they won't help get some no trespasses taken away so that he can get what he needs. This is not a violent gentleman. This is not a gentleman with mental health. This is not a gentleman with a substance abuse disorder. This is a homeless gentleman whose child was taken away from him through no fault of his own. There is no evidence that he ever did anything with respect to this child other than have 2 very good visits. This is a homeless gentleman who needed DCF's help, didn't get it, and the lower court erred by listening to DCF's generalization of the evidence rather than looking and making an even-handed assessment of the evidence. I see my time is running short. If there are no further questions, I will rest on my brief.
Check with the panel. All right, I see no questions. So thank you very much, Attorney Healy. Appreciate your argument. I will now turn next to, I believe, attorney for the child. Attorney for DCF is going to start. Is that correct?
Yes.
All right. And let me just interrupt for a moment. I realized I didn't actually call the case and the case number at the beginning of the arguments. Let me do that now. 2020-0354, Department of Children and Families versus another NFOP. Okay, so Attorney Jaspers, is that how you pronounce it?
Yes, Your Honor. Thank you.
Thank you. All right, please go.
May it please the court, Adelaida Jaspers for the appellee, the Department of Children and Families. This is a case of overwhelming parental unfitness demonstrated by the evidence of a persistent pattern of father's unavailability and indifference toward the child, as shown by his minimal contact with her, by his dismal engagement in services, and his failure to attend trial. Father was not available at the time of the child's birth because he was incarcerated for violating mother's restraining order. During the child's entire life, father has visited with her for a total of 80 minutes on 2 separate occasions. He ended the first visit 15 minutes earlier and arrived at the next visit 20 minutes late. Father has not seen her since December 6, 2018, and has not inquired about a visitation with her since February 2019. This court, in adoption of Fran, stated that abruptly ending contact with the child is tantamount to practical abandonment and indicative of parental unfitness. Father's indifference in the case is also apparent in his failure to engage in services or attend the appointments with his social worker to help him with accessing services. Instead, he showed up unannounced and maintained sporadic contact with the department, such as from the end of July 2018 to November 2018, then January and February, then April 2019, then June 2019. He also failed to attend the appointments that the social worker specifically scheduled for him to see to his access to services, and they were on multiple occasions. They were on June 20th, 2018, July 10, 2018, January 10, 2019, April 23rd, 2019, and June 18, 2019. The department called father monthly, and he only responded to those calls 10 to 20% of the time. Father also abandoned trial. Although he was present the first day of trial, he left before the court could rule on a motion to continue and never attended trial. This court, in adoption of Talley, stated that a parent's inexcusable failure to attend trial may suggest that the parent has abandoned his right to the child and is not capable of meeting her best interests. In addition to this pattern of indifference, the court found, and the evidence shows, a multitude of factors that the court considered which contributed to father's unfitness. Father has a history of parental neglect, which was one of the factors, not a dispositive factor, but a probative evidence of father's inability to care for the child. He doesn't have rights to his 5 children, does not maintain any contact with them, and was has been involved with the department in 2 separate cases as an adult. In addition, father's relationship with mother was mired in volatility and showed that he cannot control his angry outburst, and that his violent or volatile temper makes it so that he is unable to create a safe and stable environment for the child. Father's angry temperament was also apparent in his interactions with other individuals, such as community staff members, police and department personnel. His combative temper and behavioral issues also are interfered with his ability to access services and foreshadowed a risk of harm for the child. His criminal record also reveals a volatile temper. It shows 7 restraining orders that were filed against him by 7 different women, including mother, in April 2018. Also, it reflects 2 assault and battery charges, one in May 2018, another in June 2018. The later one was against a public employee, a court officer, and was still open at the time of trial. It also reflects a no trespass order at Lifebridge Shelter, which was also an open charge. Finally, the court here considered that the child has been in the care of the pre-adoptive parents since infancy and has bonded with them. They ensure that her basic and special needs are met. They ensure that she attends early intervention services that are designed to address her gross motor skills, as well as her language and speech skills, and had taught her sign language. She has made solid progress in their care. The court correctly found that it was in the best interest of the child to terminate parental rights in light of the father's overwhelming unfitness, and correctly found that she was in need of care and protection. In response to some of the arguments that my sister made, as I noted earlier, there was a multitude of factors here that contributed to a finding of unfitness. The homelessness or poverty is never a dispositive factor to find a father unfit, and the court did not find so here. As seen by the evidence in the court's findings, there is a constellation of factors that contributed to that finding, and the department made reasonable efforts in this case. Father was offered weekly visits, but only attended 2. He could have attended 60 visits. The department also provided the father with referral information to several local agencies, and was available to him even when he appeared unannounced. Unfortunately, it was father's failure to follow through with services or his own threatening behavior that was a barrier to accessing services. The department also requested father to confirm his visits after he had confirmed and missed 2 visits. That was a reasonable request from the department's side, and that the evidence also showed that father had access to a cell phone, to a government-issued cell phone at different points during the case, and used it to call his social worker. So father's argument does not explain why, when he could have had 60 visits, he only attended 2. When only 8 visits, only 13% of those visits were due to his failure to confirm. Does not explain why on other occasions he canceled those visits or did not show up after confirming, or the extended periods during which father did not contact DCF, such as from July to November 2018, then February 2019, then April, then June 11. In sum, the department respectfully asks this court to affirm the decision of the trial court. The child is entitled to and deserves permanence and stability, which would be facilitated by affirming the court's decision. If there are no further questions, I'll rest on my brief.
Seeing none? No, thank you very much. Appreciate your argument.
Questions, I'll rest on my brief.
Seeing none? No, thank you very much. Appreciate your argument.
Questions, I'll rest on my brief.
Seeing none? No, thank you very much. Appreciate your argument.
Questions, I'll rest on my brief.
I'm requesting that you affirm the judgment finding father unfit and terminating his parental rights. The court's findings and judgment were supported by the record. Father didn't solve the protective concerns.
I'm going to interrupt you for a moment. I'm sorry, Attorney Levin. I'm at least having much difficulty with lots of feedback. Interrupt you for a moment. I'm sorry.
Again, and on the record.
Okay, let's see if this.
And on the record.
Okay. So on
Okay,
behalf
let's see if this.
And on the record.
okay. So on behalf
As my brief suggests, the cornerstone to the evidence of his lack of participation was the lack of visitation, the lack of his knowledge with the child himself. Oh no. The evidence of his lack of participation was the lack of visitation, the lack of his knowledge with the child.
All right, well, let's just take time for a moment. It looks as if the problem is not resolved.
Apparently not.
No. Okay. We will be sure that we have the opportunity to hear your argument. Don't be concerned about it.
We are back live and back on the record.
And shall I resume?
Yes, please do. Again, thank you for your patience, and we will make sure that you have your full time. Go ahead and please start again.
Thank you. So I was talking about the cornerstone being the lack of visitation. And this is a father who, throughout the child's life up until the time of trial, knew her for 80 minutes. That was the total of 2 visits. 2 out of 60 possible visits, the other 58 didn't occur. Of the 2 visits, once he left early, once he came late. There were no visits in the 5.5 months prior to the trial, and the record indicates father didn't request any. Nor did father show for the day of trial, although there was a scheduled trial on the first day that didn't happen. He didn't show up the next day, and the judge made an adverse inference, a negative inference against him. There is a problem with not only this father's abandonment of the child, but the abandonment of the proceedings, because he really didn't participate in services. And the cornerstone of that is his no showing or canceling of the few meetings that he did try to set up with the social worker. He appeared to have good intentions at the outset of the case and periodically throughout the case when he would come to DCF unannounced and ask for help. That was good, but he never followed through. He canceled, he no-showed, and he did so consistently, unfortunately. And so the DCF never got a chance to work with this person. I don't think that it's a fair proposition to assert that this was DCF's fault for not working with them or providing reasonable efforts. I think adoption of Mario and its progeny indicate that the parent also has to provide good faith, reasonable efforts, him or herself, to work with the department and attempt to achieve the goal of reunification when that's the goal, or, you know, in this case, when the goal changed to adoption, to nonetheless try to work through the action plans. No action plans, however, were completed. The only ostensible services that he was credited for was finally signing up for Mass Health and engaging in those 2 visits with the child.
The other major problem with father's case from the child's perspective is his inability to provide the stability that this child needs to just meet her basic needs. The father's living on the street, been living on the street for, if not all of the case, most of the case, including, according to the record, at least 5 days before the trial. And father was, in fact, seeming to prefer living on the street. There was a time where he had a choice of living on the street or not and chose against it. The housing factor is a serious factor. While lack of housing in and of itself can't be the sole basis for an unfitness finding and a termination decree, that's not the sole finding here. That's tied into the larger picture of this parent's stability and ability to provide this child for this child's basic needs. At the time of trial, there was some indication that the child, in fact, had some special needs as well, with speech and language and potentially an eye problem. They were being handled in good measure by the foster family. But this is not a good candidate for somebody to oversee even a, quote, generic, unquote, kid without problems, let alone one who potentially has some that need attention. So the protective concerns, well, it may be true that father was not the evidence at least didn't show, that father was a violent person, that father's and mother's domestic violence was of the most serious sort. The problem was that it was a contributing factor to this constellation of problems, constellation of issues that all added up to a picture of large-scale instability that, again, led to the inescapable conclusion that he didn't have the sort of stability to provide for any child's basic needs, including this little toddler's basic needs. The child was thriving in the pre-adoptive placement. On the other hand, this child had never lived with father, nor with mother for that matter, but she's not part of this appeal. The child was placed in the pre-adoptive placement for, I want to say, roughly a year at the time of trial. She's now about 2.5 years old. She had developed a loving and attached relationship with this foster family who clearly was caring for her in a attentive and proper way that was providing for her needs. So it's been proven by clear and convincing evidence that father is unfit and that the best interests of the child do require his termination, and the child therefore would request that you affirm the lower court's judgment. I would rest on the brief at this point unless there's questions.
Thank you very much. I'll inquire of the panel if there are any, and I see none. I want to thank you very much again for your patience, for all three of you. We appreciate it. It's important that we can have these arguments and so that we can move these cases along. And I know sometimes it's problematic, but with your patience, we got through it. I also know these cases are very difficult cases, and you can be assured that we'll consider all factors very seriously and try and get an answer back to you as soon as possible. Meanwhile, on behalf of the panel, we hope that all of you and your families stay safe and healthy during the end of the pandemic, which of course we all hope will end very soon in the near future. So